proceed to trial pursuant to a few housekeeping matters and a one-part motion in limine.
Okay, if I can get Mr. Sanchez to, or Ms. Sanchez to identify themselves on the screen, please.
Yes, Your Honor. Mario Sanchez, Sanchez.
Okay, Mr. Sanchez, for some reason I have a hard time hearing you. Does everybody else hear Mr. Sanchez, or it just me?
Is that better, Your Honor?
Yes, it is. Much better. Okay, thank you very much, Mr. Sanchez. Is the plaintiff ready to proceed to trial?
Yes, Your Honor, pursuant to a few housekeeping matters and a one-part motion in limine.
Okay, if I can get the announcements of the defendants, please.
Yes, Your Honor. Emily Luco, Lucot, and Laura Gomez Duarte, Gomez Duarte, for the defendant, Mr. Darren Ryan.
Okay.
We are ready to proceed, Your Honor.
I'm going to need you to make sure that you keep your voice up as well, because it is difficult to hear you.
Yes, Your Honor. Is this better now?
No.
Okay, let me try something else. How about now, Your Honor? Is this better?
It's just slightly. You are going to need to keep your voice up. And Ms. Luca, I did not hear the name of your co-counsel. Can you please repeat that for me?
Yes, Your Honor. My co-counsel is Laura Gomez Duarte.
Okay, and can I get Mr. Duarte to identify herself on the screen, please?
Yes, Your Honor. Good afternoon. Can you hear
There
me?
you are. Yes, and I see you in the corner as well. So I've got you now too as well. Is the defendant ready for trial?
Yes, Your Honor. We're ready pursuant to a few housekeeping matters and a motion in limine in one part.
And if you indicated you had some housekeeping matters, is it Mr. Sanchez or Mr. Guerrero who will be making those motions?
I will, Your Honor.
Okay, Mr. Guerrero, you may proceed.
May we assume that all witnesses have been pre-sworn?
Yes.
And as Your Honor knows, pursuant to Federal Rule of Civil Procedure 51, the jury charge may be read prior to or after closing arguments. For purposes of this trial, may the jury charge be read prior to closing arguments?
No. Oh, prior to closing arguments? Yes. I thought you
Yes.
said prior to the beginning of the case. Prior to closing arguments, yes.
That concludes plaintiff's housekeeping.
Okay, you said you had something on motion in limiting.
Yes, Your Honor.
Please proceed.
As Your Honor knows, this negligence action arises after the defendant's vehicle struck Ms. Gray as she sat on a parked motorcycle. Now, we anticipate that the defense may discuss Ms. Gray's citation for driving without a helmet, but we ask that no mention of this citation be made, first because it is not relevant, but alternatively is improper character evidence.
Okay, what is the result of the citation? Do we know?
Your Honor, this citation did lead to a conviction, I believe.
Okay, response?
Your Honor, we do not anticipate to get into that citation at this time. However, should we decide to later, we will approach.
With that, it will be granted. Is there anything further, Mr. Guerrero?
Nothing further on the motion in limine, Your Honor.
Okay, who will be arguing limiting for the defendant?
That'll be I, Your Honor, Miss Emily Luco.
Okay, Ms. Luco, you may proceed.
Your Honor, first addressing a few housekeeping matters, may we have a 5-minute recess at the end of plaintiff's case in chief?
Okay, we'll see where we are at that time. You should make your motion your request at that time.
Yes, Your Honor. And Your Honor, as this is over Zoom, may we have permission to share our screens freely, or would you like us to ask before doing so?
I prefer that you ask, please.
Your Honor, as you know, this is a negligence case in which the plaintiff's reckless disregard for basic motor vehicle laws caused the serious injuries of Mr. Darren Ryan. Your Honor, before I proceed to our motion in limine in one part, we'd like to ask this court, as permitted under Federal Rules of Evidence 201, to take judicial notice of the Stilton motor vehicle laws, which both parties have stipulated to in this case. Specifically, Stilton motor vehicle laws requires a motorcycle driver to possess a valid motorcycle license. Second, Stilton motor vehicle laws requires a licensed motorcycle driver of less than 2 years of driving experience to wear a helmet.
Is there any objection?
No objection, Your Honor.
Okay, hearing no objection, that will be granted.
Your Honor, for our motion in limine, we anticipate that the plaintiff will get into the defendant's driving history, specifically a prior accident that occurred prior to the accident that we are here for today. Our client, Mr. Ryan, was never charged with anything involving this accident, but we anticipate that the plaintiff might use this as improper character evidence. Therefore, we ask that there's no mention of this prior accident because it is improper character evidence, it is not relevant, and any probative value is substantially outweighed by the danger of unfair prejudice and will only serve to mislead the jury.
Response, Mr. Guerrero?
With respect to the relevance objection, Your Honor, the defendant's driving history is relevant because this case is about the defendant's driving skills. So his driving history definitely has an effect on the fact of consequence in this case. With respect to propensity, we don't anticipate getting into this, but if the door is open, regarding the defendant's careful driving, then we may rebut that. We may rebut that inference that may be drawn from that. But this also with the 403 objection, this line of questioning would not be unfairly prejudicial, or because it would not inflame the jury or ask them to, or lead the jury to act on the basis of emotion or as a result of that previous issue. So I just don't believe that it would mislead or confuse the jury either.
Okay, so it's your position because he did it before, he's negligent this time? Is that what you're saying?
No, Your Honor, but again, his driving history is relevant because it speaks to his driving skills.
Okay, the motion in limine will be granted. Counsel, Ms. Lucat, be careful. If you open the door, it's coming in.
Yes, Your Honor. That concludes our motion in limine, and defense is ready to proceed to opening statements.
Okay. Who will be opening for the plaintiff?
Mario Sanchez, Your Honor.
Okay, Mr. Sanchez, are you ready to proceed with your opening statement?
Yes, Your Honor.
Okay, you may proceed.
May it please the court?
Please.
Those that rush tend to make mistakes. Mistakes can have very serious consequences. And when you're driving, a mistake can change a life. As you may recall from jury selection, I am Mario Sanchez along with my co-counsel, Stefan Guerrero, and we're here today on behalf of Carson Gray.
Okay, Mr. Sanchez, I'm sorry, but you seem to be breaking in and out. Is anybody else having a problem hearing him? I just want to make sure it is not me, that maybe it's just my computer. Is anybody else having a problem? Mr. Harrison, are you having a problem hearing him?
No, Your Honor, I can hear him all right. Thank you.
Okay, so it's the county computer. What a surprise. Okay, so let me see what, if anything, I can do here. Okay, Mr. Sanchez, you may proceed. I'm sorry for the interruption.
Yes, Your Honor. Our case will show that on September 4th, 2017, Darren Ryan's car struck Carson Gray while Carson sat in her parking spot. You'll hear testimony today about a car crash. That car crash had some serious consequences. Those consequences could have been avoided. Instead, those consequences are injuries for Carson Gray. Those injuries include fractured bones and a head injury that Carson must live with. Now, we cannot just tell you this today. We must prove it. Our side has a burden to prove what happened that day. Our burden of proof is by a preponderance of the evidence, or to put it simply, we must prove our claim more likely true than not. And our claim is that Darren Ryan was negligent while driving his car. We must prove, more likely true than not, that Darren Ryan did not act like a reasonably careful person while driving their car. We must also prove that Darren Ryan was the proximate cause of Carson Gray's injuries. Simply put, we must prove that Darren's actions were a substantial factor that led to Carson's injuries. Finally, we'll prove that those injuries severely damaged Carson Gray. You will hear from Carson Gray today. You'll hear how Carson was sitting on her motorcycle and how that motorcycle was in a parking lot. That parking spot was on the side of the road, and testimony will show that it was not a busy day. It was a sunny and warm day. The street had plenty of parking that day. It was an ordinary day that should have ended without incident. Yet, you'll hear how Darren Ryan was traveling down Webster Street. Carson Gray sat in her parking spot. She turned around and saw a car flying at her. And then, just like that, Darren Ryan struck Carson Gray. Darren Ryan was supposed to meet friends at 5 p.m. He arrived around 5:30 while one of his friends walked out the door. That motorcycle was a dream purchase for Carson. She knew how important that motorcycle was to her, and she made sure everything was done properly. She made sure to have someone hold on to the motorcycle until she was properly licensed. That person was Tony Stork. You'll hear from Tony Stork today. On that day, Tony Stork wanted to meet with Carson to talk. Tony and Carson met at Montana Max. Tony drove there on the motorcycle while Carson walked there. Carson had the perfect chance to see her motorcycle while meeting with Tony. She simply wanted to feel the rumble of her brand new motorcycle. You'll hear how Carson was not driving the motorcycle. The evidence will show that Carson did not have a helmet because she never intended to ride. The evidence will also show that the motorcycle was never in gear because she never meant to ride. The evidence will show the vehicles collided while my client sat on her parked motorcycle. Carson never saw the threat approaching because it swerved in out of nowhere. That swerve led to some serious injuries that now affect Carson's daily life. The defense will try to tell you that Carson veered into traffic, that she was at fault for driving into the street. The evidence will prove that Carson sat in that parking spot and never placed a motorcycle into gear. She simply wanted to enjoy being on it until she was properly licensed. Darren Ryan had a choice that day. Darren Ryan chose to leave home 10 minutes after 5 that day. That mistake had some serious consequences that should not have burdened Carson Gray. At the end of this case, we ask that you find that Darren Ryan was negligent for Carson Gray's injuries. We hope that you keep that issue in focus while we proceed. Thank you.
Okay, thank you, Mr. Sanchez. For the defendant who will be doing opening statement.
Emily Luco for the defense, Your Honor.
Okay, Ms. Luca, you may proceed.
May it please the court. Be alert because accidents hurt. This is just an example of some of the mottos that guide our roadways, but every good driver knows sometimes, no matter how alert you are or how careful, when the unexpected happens, someone may just get hurt. Good afternoon, ladies and gentlemen. As you may remember from jury selection, my name is Emily Luco, and alongside my co-counsel, Laura Gomez Duarte, we proudly represent the defendant in this case, Mr. Darren Ryan. I want to tell you a bit about Mr. Ryan. Now, Mr. Ryan, he has had his fair share of challenges throughout his life. At a young age, he lost both of his parents due to a tragic motorcycle accident. As a result, he had to move in with his grandmother, where he took care of her along with himself as he tried to prepare for college, something his parents always wanted for him. Like most 17-year-olds entering college for the first time, Mr. Ryan found himself consumed by typical temptations. Eventually, Mr. Ryan ended up not doing so well in school, and that's when he knew he needed to make a serious change. So what did Mr. Ryan do? He moved back in with his grandmother to save money, have less distractions, and take care of the only family he had left. Although he was keeping his eyes open for a job, he knew his main priority was school. He wanted to make his parents proud. Just as the new school year was approaching, Mr. Ryan received an invite from an old college friend, Ms. Nat Romanoff, to get together with some other friends at a local restaurant. Now, Mr. Ryan and Ms. Romanoff, they met during their freshman year at Selton Community College, and they roomed together. It was Labor Day weekend when the new restaurant opened. Mr. Ryan knew this would be a great opportunity to catch up with old friends before having to get back to school. So on September 4th, 2017, Mr. Ryan agreed to meet up at the restaurant around 5 p.m. And he planned to get there at 5 p.m., but like it usually does, time slipped away from him. So he ended up leaving around 5:10. The restaurant was 20 minutes away, and Mr. Ryan knew his accidental tardiness would mean he would miss out on meeting some of these friends, but he was really there to catch up with Miss Romanov, so he wasn't too worried. By the time Mr. Ryan was on the road, Miss Romanov, she started wondering where he was. She tried calling him, but when he didn't answer his phone, she knew he must have been close by. You see, unlike most 18-year-olds, Mr. Ryan refuses to answer his phone while driving because he knew firsthand how dangerous the road could be with the loss of his parents. When Mr. Ryan made it to Webster Street, the street that Montana Max's is located on, he began looking for a spot to park. It was a bright sunny day. There was not a lot of traffic due to the holiday. So he approached the restaurant and he saw an open space right in front of a parked motorcycle. When he saw it, he slowed his car down. He signaled to indicate he was going to park in that space when suddenly, bam! Faster than Mr. Ryan could blink, the motorcycle, the one that was parked, it wasn't in that space anymore behind him. Rather, it laid in front of Mr. Ryan's car as a result of an accident. And that's why we're here today, ladies and gentlemen. We're here today to talk about what happened in that split second. Today, we anticipate that you will hear from several witnesses about what happened in that second. You'll hear from Miss Romanov, the friend, that right before the accident, that motorcycle that was supposed to be parked on the side of the street, well, it suddenly started revving its engine. You'll hear from both Mr. Ryan and Miss Romanov that right when Mr. Ryan began to pull into the parking spot, that motorcycle sped in front of his car. You're also going to hear that Mr. Ryan, he slammed on his brakes so hard, trying to prevent this from happening, that it resulted in serious injuries to his neck and his head. You're also going to hear from the individual who was on that motorcycle at the time of the accident. That driver, that's the plaintiff in this case, Ms. Carson Gray. Now, you just heard plaintiff come up here and say that Miss Gray, she did everything right. We anticipate you're going to hear some things about Miss Gray that maybe she didn't do right that day. First, Miss Gray, the owner of that motorcycle, she had not bothered to get it titled in her name at the time of the accident. Second, that Miss Gray was sitting on a running motorcycle in a parking space parallel to moving traffic. Third, that Miss Gray, she wasn't wearing a helmet while she was sitting on a running motorcycle. And last, Miss Gray is going to have to tell you that she didn't even have a valid motorcycle's license at the time of this accident. We also anticipate that you're going to hear from Miss Gray's friend, Mr. Stork. Now, when Miss Gray and Mr. Stork take the stand today, I want you to pay special attention to the details of their story. Compare those details and ask yourself, are there any inconsistencies? Does what they're saying add up? Ladies and gentlemen, today you are here to determine a very serious question. And that question is whether our client, Mr. Ryan, acted negligently when driving that day. Now, please remember the plaintiff has the burden of proof in answering that question. That means the plaintiff must prove to you by a preponderance of the evidence that Mr. Ryan did not act in a reasonably careful manner. If you find that Mr. Ryan acted reasonably when driving that day, then the plaintiff did not meet their burden. In addition to this, we also have a responsibility to you today. It is my and my co-counsel's job to prove to you that it's more likely than not that the plaintiff acted negligently when they operated their motorcycle, that the plaintiff did not act reasonably or carefully in a manner to avoid injuring others when they drove in front of Mr. Ryan's car. Now, we welcome this responsibility, and I'm confident that we will meet our duty today. And I know that when you go back to jury deliberations, you will provide the only answer that the evidence supports and justice demands, that Mr. Ryan did not act negligently, but rather the plaintiff is the reason for this accident.
Okay, Ms. Lucat, thank you so much. Mr. Sanchez, Mr. Guerrero, you may call your first witness, please.
Plaintiff calls Carson Gray to the stand.
Okay. Ms. Gray?
May I
Ms.
proceed, Your
Gray, if
Honor?
I can get you to go ahead and unmute yourself, please. Okay. Ms. Gray has been previously sworn. Mr. Guerrero, you may proceed.
Please introduce yourself to the jury.
Hi, my name is Carson Gray.
Ms. Gray, why are we here today?
We're here because on September 4th, 2017, a vehicle driven by Darian Ryan crashed into me while I was sitting on a parked motorcycle.
Now, where did this crash occur?
It happened here in Steelton in front of Montana Max's.
What's Montana Max?
That's a local like restaurant, bar type place. They have drinks, video games, food.
Were you heading to Montana Max?
I was going to Montana Max's on that day to meet a friend and coworker, Tony Stork.
Had you gone in already when the collision occurred?
No, I had just walked there from work and I was there before my friend Tony was, so I waited outside for him.
Now, had you had anything to drink at work that day or before the collision?
No, I didn't.
And around what time did the collision occur?
I leave work usually at 5:30 and I think it was a 30-minute walk, so it must have been around 6 o'clock.
What was the weather like?
Oh, it was a really nice day. It was sunny and clear outside and not too cold yet, which was really part of the reason I decided to walk there because fall was coming and I knew we didn't have a whole lot of nice days left.
Was the sun still out prior to the accident?
Yes, it was still sunny outside.
Now, were you on your motorcycle when the collision occurred?
Yeah, when Tony had gotten there, I went ahead and I had my motorcycle license test the next day, so I went ahead and sat on the motorcycle.
Now, why did Tony drive it if this motorcycle was yours?
So I didn't have my license yet, and he did have a license and didn't have a motorcycle, so I let him keep it. He'd help me out by driving the motorcycle to like the driving center, for example. So I let him go ahead and keep it until I had my license.
And was the motorcycle on while you sat on it?
Yes, he had left it on, so it was still on, but it wasn't parked.
Were you planning on driving it anywhere?
No, like I said, we had just gotten there to meet for to chat and hang out. So I just wanted to sit on it, kind of get some good vibes for my test the next day. But we were still going to go inside to Montana Max's and hang out.
Were you prepared for your test that next day?
Yeah, I mean, we had, I had already done all of the prereqs as far as like the little trainings and videos that you had to do to be able to take the test. So I was prepared.
And were you wearing a helmet when you sat on the motorcycle?
No, I wasn't planning on driving it or going anywhere. I just wanted to sit on it while it was parked in that parking spot. So I didn't put a helmet on.
Did you ever put the motorcycle into gear?
No, I didn't. It was not in gear.
Now let's talk more about the scene of the collision. What street did this collision occur on?
This happened on Webster Street.
Ms. Gray, would it be helpful for the jury's understanding to show the street and the location of your motorcycle at the time of the collision?
Yes, I think it would.
Your Honor, does Ms. Gray have permission to share screen for the purpose of creating a demonstrative?
Yes.
Ms. Gray, can you show us Webster Street?
Great. So Webster Street is a pretty long straight street. I'm just gonna draw that part of it that's right there and mark it with a W for Webster.
Is this the same street that Montana Max is located on?
Yes, Montana Max's is on the right side of the street, so I'll just draw it in that rectangle with a MM in there for Montana Max.
Were there any parking spaces available on the street?
Yes, there's street parking that's parallel parking, so they're a little longer than other parking spots might be, but they're right along of the street.
Was parking available on both sides or just in front of the restaurant?
There is parking on both sides of the street, so there's plenty.
Now, about where was your motorcycle parked?
My motorcycle was on the same side of the street as Montana Max's, on the right side, in a parking spot, not right in front of it, but a little off to the left, a little before you get to Montana Max's if you're driving on the right side of the street, right about here.
Do you recall if any other vehicles were parked there on the street?
I'm sure there were, yes, there were other vehicles, although it was Labor Day, so it was a little less empty than usual. So there was also plenty of parking available.
Now, where was the defendant's vehicle when the collision occurred?
So when the collision occurred, the vehicle was right behind me because I'd looked just in time to see it barreling at me. So it hit me from behind, right about there where that red square is the vehicle.
Your Honor, may this be preserved as plaintiff's demonstrative A?
Yes.
Now, Ms. Gray, did you see anything before the crash occurred?
Well, I had looked back just in time to see the car barreling at me, and then it hit me.
So this car had just turned onto Webster before the accident occurred, right?
Well, it was driving on Webster because that's where the parking is and that's where I was parked. So it did hit me while I was parked on Webster Street.
Now let's discuss your injuries. Were you injured as a result of this crash?
Your Honor, objection, may we approach?
Yes.
Your Honor, assuming we're constructively outside the presence of the jury, we would believe that the next line of questioning plaintiff's counsel is going to get into has to deal with the injuries sustained by Ms. Gray. As you know, this is a bifurcated trial. Therefore, we would ask that no mention in terms of the extent of her injuries, how long they lasted, or the effects after the accident would be mentioned at this time. We're just here for the liability phase.
Okay, response?
Your Honor, injuries are an element of negligence, and it is the jury's responsibility to determine if there are true injuries in this case. For that reason, the extent of the injuries are relevant, even with this bifurcated trial on liability.
Okay.
Your
Your
Honor.
question is sustained. You can answer the question that was asked, but you will go no further into the injury issue.
Ms. Gray, were you injured after the crash?
Yes, I was injured. I had to go to the hospital.
No further questions, Your Honor. I pass the witness.
Okay, cross-examination?
Yes, Your Honor. May I proceed?
Yes.
Ms. Gray, I'd like to ask you a few questions about the accident that you were just talking to your attorney about. It's true that at the time of the accident, you did not possess a valid motorcycle license.
No, I didn't yet. My test was the next day.
And you were feeling pretty prepared for that test, right?
Yes.
And you had to prepare for that test significantly, didn't you?
Yeah, there were prereqs to being able to go take the test, and I've done those.
And this is because you had failed the test previously.
I had taken the test before and I had failed it by a point. Unfortunately, it was a big bummer, but I was ready to take it again.
Miss Gray, this motorcycle, it was yours, correct?
Yeah, I bought it.
The motorcycle was titled in your name.
Was eventually, yeah, I bought it.
What you stated it was eventually. You're saying the motorcycle wasn't titled in your name at the time of the accident?
I don't really know about the timing of all the paperwork that everything gets done. I just know that I bought it on a day and they delivered it to me, so it was mine.
Your Honor, may I approach for the purpose of introducing evidence?
Approach the witness or approach me?
Your Honor, I would like to approach the witness regarding this evidence, but I understand that over Zoom, you might prefer that my foundation is laid constructively outside the presence of the
You
jury.
can do it in front of the jury.
Okay, then I would like to approach the witness.
Okay, granted.
Okay. Sorry, just one moment, please. Okay. Ms. Gray, can you see my screen?
Yes.
Should be looking at Exhibit A. Your Honor, are you able to see Exhibit A?
Yes.
Ms. Gray, without getting into the contents of this exhibit, you recognize this exhibit, don't you?
Yes.
This exhibit, Exhibit A, is the title certificate for your motorcycle?
Yes, it is.
And you would agree with me that this exhibit is a true and correct copy of the title certificate?
Mhm.
Your Honor, at this time, we offer Exhibit A into evidence and tender to opposing counsel.
Okay, Mr. Guerrero, any objection?
Yes, Your Honor. Hearsay?
Your Honor, may I be heard?
You can respond to the hearsay objection.
Your Honor, this is not hearsay. This is admission by a party opponent.
That exception is not applicable. Do you have another one?
Your Honor, we would just state that, Your Honor, we would
The
just state
hearsay
that.
objection will be sustained.
I'll stop sharing my screen now.
Your Honor, may the jury have a limiting instruction as to any document shown?
Well, because we're assuming that everybody saw it on Zoom, yep, you get a limiting instruction. Y'all need to ignore what you just saw.
Your Honor, just to be clear, though, we're still able to ask questions about the title certificate.
Well, it depends on the question and whether you get an objection.
Yes, Your Honor. Ms. Gray, you would agree with me that when you received title of your motorcycle, that was on October 15th, 2017.
Sure.
That would mean that you did not have the motorcycle titled in your name until 42 days after the accident.
Yeah, I guess that's what it officially means.
Ms. Gray, you have experience riding motorcycles, don't you?
I used to do dirt bike racing when I was a kid, not necessarily motorcycles.
But you'd agree with me that you believe dirt bikes are pretty similar to motorcycles, correct?
Kind of. When comparing them to regular cars, sure, but they're not quite the same, which is why you need a different license for them.
Is it your testimony today that you would say that motorcycles and BMX bikes are not very similar?
They're not exactly the same.
Ms. Gray, have you ever testified differently before?
No.
Ms. Gray, you remember giving prior testimony in this case?
I did.
And you swore to tell the truth?
I did.
The whole truth?
Mm-hmm.
But nothing but the truth?
Right.
Your Honor, may I approach for the
Yes.
sake of, thank you. Ms. Gray, I'm showing you your deposition, and I'll go to the top so you can see that this is the deposition for Carson Gray. That's you, correct?
Yes, that's me.
Okay. Ms. Gray, I'm now going to go down to page 20 of your deposition. And I would like to read a few lines for you. Starting at line 9, please follow along, and if I read anything incorrectly, you can let me know. This is you talking. When I was a kid and into my teens, I was pretty big into dirt bike racing. Do you mean BMX? No, I mean real dirt bike racing. So for a very long time, I was riding dirt bikes, which are essentially motorcycles specifically made for racing on dirt tracks. Did I read that correctly?
Yes, you did.
Okay, so Ms. Gray, you'd agree with me that you've previously testified that you find motorcycles and dirt bikes to be essentially the same.
No, I said that dirt bikes are like motorcycles but made for the dirt. So they're not exactly the same.
Okay, Ms. Gray, is it your testimony that you're not familiar with riding motorcycles from that previous experience?
No, like I said, I'm experienced, or I used to do dirt bike racing, and now now I ride motorcycles because that's what I have a license in.
So your testimony today is you're not very familiar with riding motorcycles.
I'm familiar now, yes.
Ms. Gray, I just want to be very clear. At the time of the accident, is it your testimony that you are not very familiar with riding motorcycles?
I was familiar to the extent I needed to be licensed to drive it and take the motorcycle test.
And your current motorcycle, that's a Grandmaster Hurley, isn't it?
Yes.
And you'd agree with me that a Grandmaster Hurley, that's a large bike, right?
Sure.
And a Grandmaster Hurley, it's significantly larger than your previous experience riding on BMX bikes.
Yes, that's why they're different.
And that's why you wanted to get on that day to build your confidence.
Just to get a feel for it and get some good vibes for the next day. That's it.
You're trying to get pumped and excited for that test you had?
Yeah, I wanted to feel good about the next day.
And of course, you don't want the jury in any way to think that you were going to take that Grandmaster Hurley for a quick spin, were you?
No, because I wasn't.
Yes, but Ms. Gray, you are aware that a witness saw you remove your kickstand from the motorcycle right before the accident, aren't you?
Objection assumes facts not in evidence.
Response, Ms. Lucan?
Your Honor, I'm simply asking if this witness was aware about this, to which, if you allow me to proceed with this line of questioning, you will find that the answer is yes. This
You'll
goes
have to rephrase. The objection is sustained.
Ms. Gray, it's your testimony that the kickstand was down at the time of the accident, right?
Yes, it was.
But you're aware that a witness saw you remove the kickstand from the motorcycle right before the accident.
Objection hearsay.
Sustained.
Your Honor, may I briefly be heard?
No.
Your Honor, may the jury be instructed to disregard that line
No.
of questioning?
Ms. Gray, you would agree with me that you do not want the jury to think you removed the kickstand because that would not look good for your case, would it?
Objection, compound question.
Overruled. You may answer the question, Ms. Gray.
I wouldn't want them to think that because that's not true.
Okay, Ms. Gray. Just a few more questions for you. When you were standing outside of Montana Max, you said Mr. Stork had just pulled up into that parking spot 5 minutes before the accident. Is that right?
Yeah.
And Mr. Stork, that's one of the witnesses you and your counsel brought today to testify on your behalf.
Yeah, he was there, so he saw the accident too.
So you would expect if Mr. Stork were to take the stand for his testimony to be similar to the testimony you're giving us.
Objection, speculation.
Response?
Your Honor, if this witness, it's not speculation, they would know if they expect it or not. Yes, Your Honor. Ms. Gray, would it surprise you if Mr. Stork had already been at Montana Max's for several hours prior to the accident?
I'm not sure what Tony was doing that day. I know he didn't go to work like I did, so I don't know what he had done that day.
And Ms. Gray, you said that because Mr. Stork had just arrived to the accident, when you hopped on the motorcycle, it was already running, right?
Yes.
Would it surprise you if Mr. Stork testified that you're the one who turned it on?
Objection, speculation, and hearsay, motion to strike.
Response.
Your Honor, again, this is not speculation. This witness can just testify to their own opinions on whether or not they would be surprised if their witness contradicted their story. As you heard, this witness just stated that they expect their witness to say the exact same they are. So I'm just asking questions of, well, what if that didn't happen?
Yeah, with that response, it's sustained.
Miss Gray, you were injured as a result of the accident, right?
I was.
But you didn't realize you were injured until a day or two later after the accident, right?
Objection, Your Honor, may we approach?
What is your objection?
Relevance?
Yeah. Response, Ms. Lucat, you actually objected that the injuries have no relevance here, and now you're trying to talk about the injuries. Are you opening the door, or are you withdrawing your question?
Your Honor, I simply am asking about the injuries in terms of, as plaintiff's counsel was
Sure.
allowed to
Did
ask.
you hear my question, counsel? Are
Yes,
you opening the door or withdrawing your question?
I'll withdraw my question, Your Honor.
Okay, you may proceed.
No further questions, Your Honor.
I'm sorry?
No further questions.
Okay, thank you. Is there anything on redirect?
A brief redirect, Your Honor. Ms. Gray, did you own your motorcycle prior to the crash?
I mean, I bought it and I had it. So yeah, I owned it.
And had you completed all training and safety courses prior to the crash?
Yes. Because my test was the next day, so I had to have already done all that.
No further questions, Your Honor. May this witness be excused?
Well, I would normally ask if there's any recross. Is that not permitted?
It's not permitted, Your Honor.
Thank you. Yes, the witness may be excused. Ms. Lucat, may the witness be excused?
Yes, Your Honor.
Okay, thank you. You are excused, Ms. Gray. You may call your next witness. Plaintiff may call the next witness.
Plaintiff calls Tony Stork to the stand.
Okay, Mr. Stark, you've been previously sworn. You may proceed, Mr. Sanchez.
Hello, can you please introduce yourself to the jury, Mr. Stork?
Hi, my name is Tony Stork.
Do you know Miss Gray, the plaintiff in this case?
I do, yeah. We met at summer camp back in middle school. We've been friends since.
Have you ever worked with Miss Gray?
Yeah, we actually worked for a while at this company called Dr. Google together.
What is Dr. Google?
So basically, it's this company that provides online medical advice to people.
Do you enjoy working at Dr. Google with Carson?
Oh, yeah, we did. We had a good time working together. I actually am not at Dr. Google anymore. I left a few months prior to the accident.
Oh, where do you work now?
I actually work at Montana Max's. I'm a pretty frequent customer there, and the owner and I just thought it would be a good fit.
Mr. Stork, do you know why you're here?
Yeah, I witnessed the accident when Carson was hit by the defendant.
Let's talk about the day of the accident. Why were you meeting Carson?
We were both into motocross and just wanted to catch up.
And where did you meet Carson?
We met outside of Montana Max's.
How did you get to Montana Max?
I actually drove Carson's motorcycle there. I had been holding onto it for her.
Why did you have Carson's motorcycle?
She wasn't licensed yet, and I did have a motorcycle license, so I was just holding onto it until she passed the test.
Did you use a helmet while using the motorcycle?
Yes, of course.
And where did you park that motorcycle?
I parked it in one of the parallel parking spots, right outside of Montana Max's.
When did you meet Carson?
I met Carson sometime 5:30, 6, something like that.
Did you both arrive at the same time?
No, I'd actually gotten there a few hours earlier, around 3 or 4 or so.
What did you do while you waited for Carson?
I went inside, ate some tacos, had a few drinks. It was Labor Day, so I wasn't working that day. It's just hanging out.
Did you feel intoxicated in any way?
I had a little buzz going, but No, I wasn't intoxicated.
Let's talk about the accident itself. Now, when the collision happened, where were you?
So I was standing to the right of the bike, kind of between the bike and the sidewalk, just standing next to Carson on the bike.
Now, when the accident happened, what direction or which way were you facing?
So I was looking at Carson, kind of looking down the street to the east.
What was Carson doing?
She was just sitting on the bike.
Why was Carson on the bike?
She'd
Speculation.
I'm sorry, I didn't hear you.
Objection, speculation.
What was Carson doing on the bike? That objection is sustained. You can reword the question.
Was Carson going to drive the bike?
Objection, speculation.
Sustained. What did you observe Carson doing?
Did you see Carson drive the bike?
No, I didn't.
Was Carson wearing a helmet?
No, she wasn't driving, so she didn't need a helmet.
Did Carson move the motorcycle from the parking spot?
No, not at all.
What was Carson doing when she was struck?
She was just sitting there.
Did you see the car coming down the road?
Yeah, I did. I saw them driving down the road. The driver had waved at somebody on the sidewalk, and then they sort of just swerved right into Carson.
Did you see what the driver was doing before the accident?
Yeah, like I said, they had waved at somebody on the sidewalk. Maybe they were trying to park or something and just swerved right into Carson.
Now, did you see how Carson was struck?
Yeah, she was struck kind of the back left side of the motorcycle because it was facing forward in the parking spot, and the car swerved into her and hit the back left portion of the motorcycle.
Was Carson hurt?
Yeah, I mean there was blood everywhere.
That'll be all, Mr. Stork. Thank you. Plaintiff passes the witness, Your Honor.
Cross-examination, Mr. Rente?
Yes, Your Honor. May I proceed?
Yes, please.
Good afternoon, Mr. Stork. I have some questions for you. Now, Mr. Stork, you first met Miss Gray in middle school summer camp, correct?
Yes, that's right.
Used to ride motocross bicycles together?
Yeah, we both liked motocross.
And Miss Gray moved to Steelton where you were living.
Yes, that's right.
You recommended her, and soon you were both working together at Dr. Googly, correct?
Yeah, that's right.
And now you're working at a bar, Montana Max, correct?
Yes.
Now, Mr. Stork, I want to talk about Monday, September 4th, 2017. You were not working that day because it was Labor Day.
That's correct.
And you were to meet up with Mrs. Gray at that bar around 6 o'clock?
Yeah, sounds about right.
And you drove Mrs. Gray's motorcycle to the bar.
Yes.
But you arrived early, around 3 or 4 p.m. Is that what you said?
Yeah, I think that's about right. Yeah.
And you parked Mrs. Gray's motorcycle on the street in front of the bar.
That's correct.
And while you were waiting for Miss Gray, to arrive, you enjoyed some drinks for Margarita Monday.
Yeah, that's right.
And you had a couple of margaritas and a couple of beers?
Yeah, a few margaritas, a couple of Coronas.
So a few margaritas, about 3 or 4 margaritas, correct?
Yeah, that's probably about right.
And soon Miss Gray arrived, correct?
I mean, she did work that day. I think she left work 5:30 or so and arrived after that. Yeah.
So Miss Gray arrived, you two met around 5:30.
It was a little after 5:30. I think she left work at 5:30.
That's fair. Now, do you usually consume a few margaritas and a few beers every holiday, or was it because it was a Monday, or?
Yeah, I mean, I enjoy some drinks on the holidays. Yeah, it's fair to say.
Okay, so you would agree with me that it's fair to say that you had a little buzz going on this holiday, yeah?
Little buzz, nothing more.
Okay, and when Miss Gray arrived, you asked her if she wanted to sit on her bike, right?
Yeah, I mean, she had had a bad day. Thought it might make her feel better.
So caring. And Miss Gray hopped on the bike and turned on the ignition, right?
Yes.
And Miss Gray was not wearing a helmet while she was on the motorcycle, correct?
She wasn't going to drive, so no.
The yes or no? She was not wearing a helmet, correct?
She was not wearing a helmet.
And next thing you know, you see a car coming up towards you and Miss Gray, right?
Yeah.
That's when the collision happened, right?
Mm-hmm.
Now, prior to the accident, Mr. Stork, had you ever seen my client, Mr. Ryan?
No.
Now, Mr. Stork, I want to ask you some questions about that motorcycle.
Okay.
To your knowledge, Miss Gray purchased a 2016 Grandmaster Hurley prior to the accident, correct?
Yes.
And prior to the accident, Miss Gray did not have a valid motorcycle driver's license.
Yeah, she was taking her test the next day.
Right, because she had failed the last test, correct?
By a
Objection,
point,
Your
yeah.
Honor.
What is your objection, Mr. Sanchez?
Relevance, Your Honor.
Okay, well, it's already in evidence, so it's really not an issue. Sorry.
Now, Mr. Stork, Miss Gray let you hold on to that motorcycle because you had a valid motorcycle license, correct?
Yeah.
And you'd agree with me in preparation for the test that Miss Gray had driven the motorcycle prior to that accident.
She had practiced in the parking lot.
So is your testimony, yes, she had driven the motorcycle before the accident?
In the parking lot, yes.
And last question, Mr. Stork, although you had the bike, Miss Gray had never transferred title or registered the bike under your name. Is that correct?
Objection, Your Honor. Calls for speculation.
Whether he ever registered the bike under his name? Is that the question?
Yes, Your Honor.
It's overruled.
Can you ask it one more time?
Of course, Mr. Stork. Although you had the bike was never titled or registered under your name, correct?
Not that I know of.
Thank you, Your Honor. No further questions.
Okay, is there anything on redirect?
Yes, Your Honor, briefly. Mr. Stork, the alcohol you consumed, did it affect your perception?
No.
Did it affect your memory?
No.
That'll be all, Mr. Stork. Thank you.
Okay. May the witness be excused, Mr. Sanchez?
Yes, Your Honor.
Ms. Durante?
Yes, Your Honor.
Okay, Mr. Stark, you are excused. Thank you.
Thank you, Your Honor.
Okay, plaintiff may call their next witness.
Plaintiff, rest, Your Honor.
Okay, thank you. So we've been going approximately an hour. So at this time, why don't we go ahead and take a 10-minute break? I will see you back here at 4:10.
Your Honor, prior to taking the break, may I make a motion?
No, we'll do that when we get back. I said we're going to take a break and we're going to do it in 10 minutes, and then you can make any motion you would like when we get back.
Thank you, Your Honor.
Thank you. Are we all ready to proceed?
Yes, Your Honor.
Right, Mr. Ante, I think before we took our break, you wanted to make a motion.
Yes, Your Honor. May I
You
proceed?
may proceed.
Your Honor, as the defense, we would like to make a motion for judgment as a matter of law. As you know, this case is about negligence. The plaintiff had the burden to prove that it was more likely than not true that there was a duty breached, and that breach of duty was a proximate cause of the injuries. The plaintiff has established that both Ms. Gray and Mr. Ryan were operating vehicles on the street, and therefore they owed each other a duty as motor operators. The plaintiff, however, has failed to establish if and how my client, Mr. Ryan, violated that duty. In fact, we've heard that the plaintiff had no motorcycle license and no helmet and no registration while sitting on a running motorcycle, located on the street parallel to moving traffic. It's an undisputed breach of the duty that Steelton motorists have. Second, the plaintiff has failed to show that any of Mr. Ryan's actions were a substantial factor in Ms. Gray's injuries. The evidence the plaintiff has presented so far, in fact, suggests that their own actions, as well as lack thereof, were a substantial factor for their injuries. Having failed to meet this burden, Your Honor, we ask that you consider and grant our motion.
Mr. Guerrero, response?
Your Honor, regarding evidence of the defendant's breach of a duty, the testimony has established that on the date of the accident or the crash, it was a clear and sunny day with ample parking. Yet when Ms. Gray turned around, she saw the defendant barreling toward her. This is evidence that the defendant failed to act in a reasonably careful manner and thus breached his duty to Ms. Gray. Now, regarding the causation of injury, Ms. Gray again testified that she was injured and was taken to the hospital after this accident.
Okay, well, actually, I didn't hear anything about the hospital, but that is for the bifurcated portion of the trial. At this time, the motion for directed verdict will be denied. Okay, Mr. Ante, is the defense ready to call its first witness?
Yes, Your Honor. At this time, we would like to call Mr. Darren Ryan to the stand.
Okay.
May I proceed, Your Honor?
Mr. Ryan, you have been previously sworn. You may proceed, Mr. Ante.
Can you all hear me?
Yes, Mr. Ryan.
Yes.
Good afternoon, Mr. Ryan. Will you please introduce yourself to the jury?
Hello, my name is Darren Ryan.
And Mr. Ryan, have you testified before?
No,
Where do you currently live?
I live in Steelton along Silver Lane.
And how long have you lived in Steelton?
Well, it's been quite a while. I've been living in Steelton ever since I was a kid. I'd say that I was raised there.
Okay. Now, Mr. Ryan, I want to talk to you about why we're here today. So let's talk about Monday, September 4th, 2017. How old were you on that day?
I was 18 years old on that day.
Oh, you were just a kid. Were you living with your parents at that time?
No, unfortunately, my parents, they passed away in a motorcycle accident. So I'm living with my grandma right now.
I'm so sorry to hear that, Mr. Ryan. Now, what plans, if any, did you have on that day?
Well, I was going to meet a friend,
And what friend was that?
Miss Romanov.
And how long have you known Miss Romanoff?
Not long. We were college roommates for just like a little bit.
And so when and where were you to meet with Miss Romanoff?
We were to meet around 5 o'clock at this restaurant called Montana Max's.
Okay. And what time did you leave your house to meet Miss Romanoff?
So I left around 5:10, I believe.
And how were you planning on getting there that day?
I was planning on driving my car there that day.
How long does it usually take for you to drive your car from your grandmother's house to the restaurant?
So normally it's about 20 minutes. That day was Labor Day. I remember the traffic conditions being very light. So 20 minutes, give or take, you know.
Wait, now, Mr. Wright, you were to meet at 5 and you left at 5:10. Does it matter that you were running late for this meeting?
No, I was just going to hang out with some friends. It was not like anything serious. So I was just casually going there.
Okay. And Mr. Ryan, did you have a valid driver's license on that day?
Yes, I did.
What kind of car were you driving?
I was driving a Ford Focus.
will you please describe to the jury what kind of a car a Ford Focus is?
Sure. It's like a small compact car, 4 doors, similar to like a Honda Civic.
So, Mr. Ryan, you drove the car. Did you receive a phone call while you were driving did you receive a phone call while you were driving?
I do not remember, to be honest with you. I never answer the phone while driving. It's always off to the side. I'm pretty careful since my parents passed away in a car accident or motorcycle accident. Pardon me.
And Mr. Ryan, where is the restaurant located?
It's located along Webster Street. It's actually a street I'm pretty familiar with.
So I want to talk about the scene of the crash, Mr. Ryan. Do you think it would be helpful for the jury's understanding to show the placement of your vehicle, the motorcycle, and the restaurant?
I think so.
Your Honor, do we have permission to share screens so that Mr. Ryan may create a demonstrative illustrating the scene of the crash?
Yes.
Mr.
Okay.
Ryan? Oh,
Can y'all still hear me?
Yes.
yes. Your Honor,
Okay, give me one moment, please, okay?
Your Honor, are you able to see the screen?
Yes.
Opposing counsel, are you able to see the screen?
Yes.
Okay, I'm prepared.
Mr. Ryan, will you please show the jury what street the restaurant is located on?
Sure. Montana Max's is located along, oh, hold on, let me change the color for ease of sight. Montana Max's is located along Webster Street. It is a fairly popular street normally in Steelton, although, like I said, today was a holiday, so traffic conditions were relatively light.
Okay.
It's a street where a lot of restaurants are located. I'll go ahead and label the street for y'all.
And will you please show the jury with the rectangle where Montana Max is in relation to the street?
Absolutely. Montana Max is located right here alongside the street, and I will go ahead and label that as well for y'all.
Now, Mr. Ryan, you arrive at the restaurant. Where do you look for parking?
I look for parking alongside the road.
Will you please show the jury where the parking spaces you saw available were on that day?
Sure. So along Webster Street, there's a lot of street parking. And normally it would be pretty busy, but today, like I said, it was a holiday. There was a lot of street parking available. And I remember many of the spots being empty. And so there was parking all along the street here where you can just pull in.
Okay, and Mr. Ryan, as you see the parking spaces, do you notice a motorcycle?
I did.
Was there anyone on or near that motorcycle?
Yes, there was somebody sitting on the motorcycle. I particularly remember because I noticed they were not wearing a helmet, which I thought was unsafe.
And with a capital letter M, will you please mark the space in which you saw the motorcycle?
Sure, and I'll even change the color to make it noticeable. Capital M. Y'all can see that, correct?
Yes, Mr. Ryan.
Perfect.
Now, Mr. Ryan, will you please draw an arrow indicating the direction your car was traveling in?
Sure. My car was traveling, excuse me, this way along the road.
And were you looking to park in front or behind that motorcycle?
I was looking to park in the space in front of the motorcycle.
With a capital letter O, will you please indicate the markings? Will you please indicate the parking space you were interested in parking in?
Absolutely, and I'll try my best to make the O as neat as possible with this Zoom whiteboard, you know? There you go, how's that?
That looks good, Mr. Ryan. At any time, Mr. Ryan, did you indicate your intention to pull into that parking space?
I did.
And how did you do so?
So what I did was I slowed down and I put my signal on, which I think is pretty customary.
Will you please draw an arrow indicating the direction you were going to pull into that parking space?
Sure, like I said, I was going straight alongside the road. Then I slowed down and signaled and began to try and turn into this spot in this direction here.
Now, wait a minute, Mr. Ryan. You're telling me these are parallel parking spaces and you're pulling head first into a parking spot?
Yeah, well, normally if there was a car like in front of where I was trying to park, I would reverse into the spot. But like I said, there was not a lot of parking that day, so I could just pull in just straight in.
And Mr. Ryan, on that day, were you able to park your car in that parking space?
I was not.
And why weren't you?
Well, the motorcycle suddenly pulled out in front of me, causing a collision, which was unfortunate. I couldn't stop the car in time because it was so unexpected and surprising.
Will you please draw an arrow indicating the direction Miss Gray drove the motorcycle forward?
Sure. Let me pick a color that's easy to see. The motorcycle was driven forward like this.
At any time before the motorcycle moved, did you see any indication that it was going to move?
No indication, no signaling. Like I said, the driver had no helmet on. She just pulled out into the street very suddenly.
And Mr. Ryan, will you indicate on your drawing where it was that the vehicles crashed?
Yes, it's right where these lines intersect, but I can just go ahead and put a big X through there for y'all.
After the collision, where was the motorcycle in relation to your vehicle, Mr. Ryan?
The motorcycle was in front of my car.
And was the motorcycle in front of your car on the street or in the sidewalk?
It was in the street. Like I said, it pulled out in front of me into the street.
Your Honor, at this time, we ask that this illustration be preserved as defense demonstrative A.
Any objection?
No objections, Your Honor.
So noted.
Mr. Ryan, you can stop sharing your screen now. Thank you.
Okay. How's that?
I can see you now, Mr. Ryan.
Perfect.
Now, Mr. Ryan, what happened after the after the crash?
Well, obviously it was very sudden. Things were kind of hectic. I got out of my car and the police arrived.
And what did the police do?
They created an accident report and they just made sure everything was okay. They pretty much just followed their duties and checked in on everyone.
Permission to share screen, Your Honor, for purpose of introducing evidence. Would you like this to be done constructively outside the presence of the jury, or?
That's fine.
Objection, Your Honor. Hearsay?
Your Honor,
I
if I'm-
don't know what's happening yet. I can't, we're constructively outside the presence of the jury. So let me see what she's putting up.
Are you able to see my screen, Your Honor?
Okay, I am now.
And may I respond to the hearsay exception? Excuse me, may I respond to the hearsay objection?
Okay.
Your Honor, this is what you're seeing here is page 3 of the accident report that has been pre-marked Exhibit C. This is not hearsay. It falls under the hearsay exception under Federal Rules of Evidence 803-8. It is a public record that was created by someone under a legal duty to report. And under Federal Rules of Evidence 803-1, it was a present sense impression drawn by the police officer who is not available today to testify as a witness.
Okay,
Your Honor,
response?
Your Honor, this is not a self-authenticating document. It is an out-of-court statement offered to assert the proof of the matter. The police officer is not here to testify to that specific document.
Okay. Ms. Durante, is this a certified copy of the police report?
It has the signature, Your Honor, but I do not see certification. As for the authentication, I believe both parties have stipulated that the exhibits are authentic and correct.
So the stipulation is as to authenticity, but is it as to admissibility?
No, Your Honor, I was merely addressing a counsel's claim that this is not authentic. For admissibility, I re-urge my 803-1 and 803-8 exceptions that show that this is admissible evidence under the present sense impression exception and the public record exception.
Okay, but in order to admit a public record, is it required to be a certified copy?
No, Your Honor.
No?
Under 803-8A, it does not, I'm looking at the rules and I don't see a certification
I have the state rules in front of me, so unfortunately, I'm not looking at the federal rules. And so, counsel, you are an officer of the court. If you are looking at the federal rules, does it require a certified copy?
No, Your Honor.
If it doesn't require a certified copy, then in that case, the objection will be overruled.
Your Honor, at this time, I ask that page 3 of Exhibit C be admitted into evidence.
It is admitted over objection.
Now, Mr. Ryan, you would agree with me that this is page 3 of the accident report.
Yes,
And this is the drawing that the responding police officer created after the crash, correct?
yes, it is.
Mr. Ryan, Unit 1 here, whose vehicle is that?
That's my car, my Ford Focus.
And Unit 2?
That's the motorcycle that pulled out in front of me. I believe it was like
And-
a Harley Davidson.
Yes, I apologize for interrupting you, Mr. Ryan. Now, this line that we see here, is that the street or the sidewalk? What is that?
That would be the side of the street.
Thank you, Mr. Ryan. Now, Mr. Ryan, at the time of the collision, were you wearing a seatbelt?
I was.
And did you sustain injuries from this crash?
I did.
No further questions, Your Honor. We are ready to pass the witness.
Mr. Sanchez, ready for cross-examination?
Yes, Your Honor. May I proceed?
Yes.
Mr. Ryan, you're going to meet your friends at Montana Max for food and video games. Isn't that right?
That's true.
Let's talk about your day. You were supposed to meet your friends at 5 p.m.,
I was.
but you left your house 10 minutes after 5.
Yes, I was not in a rush.
And it takes you about 20 minutes to get to Montana Max.
Yes, as I stated before, give or take 20 minutes.
Then you got to Montana Max around 5:30.
Yes, about.
Didn't one of Nat's friends need to leave at 5:30 sharp though?
Yes, there was plans for us to meet around that time, but he had offered me a job opportunity and I wasn't taking it seriously because I was focusing on
Ryan.
school at the time.
Mr. Ryan, if you could just answer the question that I asked and I'll follow up.
Sure.
And that friend was going to talk to you about a job, right?
Yes.
Let's talk about your arrival. Nat was outside.
Yes.
You know that because you noticed Nat as you arrived?
Yes. I briefly saw him waving at me.
Because Nat was walking a friend out.
Can you repeat that? I'm sorry.
Because Nat was walking a friend out?
I believe so.
The friend that wanted to talk about the job with you?
I'm really not sure. All I saw was Nat wave at me because I briefly looked over, like I said.
Now, you drove there
Yes, I drove my Ford Focus there.
in your car. The weather was nice, wasn't it?
Yes, it was a clear day.
And you drove on Webster Street to get to Montana Max
Yes.
because Montana Max is located on Webster,
Yes.
like most of the other restaurants in town.
I mean, I guess there's a lot of restaurants on Webster Street.
And you've been going to that part of town since you were a kid.
Correct.
So you're familiar with the area.
Yes, I am.
It was Labor Day, right?
Yes, it was Labor Day. I remember because the traffic conditions were light.
The streets weren't busy.
No, it was a lighter day, lighter traffic.
You saw a bunch of parking spots available on the street.
Yes, most of the parking spaces were open.
Yet you were involved in an accident with my client, Miss Gray, right?
The motorcycle pulled out in front of me and there was a collision.
Mr. Ryan, were you involved in a collision?
Yes, when the motorcycle pulled out in front of me.
Is that a yes?
Yes.
Now, for your arrival, you turned onto Webster Street.
Objection asked and answered.
Overruled.
You turned onto Webster Street.
Yes.
You saw Nat looking at you.
I just saw Nat waving at me when I looked at him. I looked at him briefly. Sorry, her briefly.
You saw several empty parking spots.
Yes, as I said, I saw several open parking spots
You turned on your turn signal
and I slowed down, correct?
and you started slowing down, isn't that right?
Yes, like I said.
Yet you hit your brakes so hard that you even broke some bones in your neck, isn't that right?
Like I said, the motorcycle darted in front of me, cut in front of me, so I slammed my brakes, causing me to break my neck and suffer from a concussion.
Well, Mr. Ryan, you were in a car, right?
I was in my car, correct?
And Miss Gray was on her motorcycle?
Yes.
That'll be all, Mr. Ryan. Thank you.
Okay, anything on redirect?
No, Your Honor.
Okay, may the witness be excused?
Yes, Your Honor.
Mr. Sanchez?
Yes, Your Honor.
Okay, Mr. Ryan, you're excused. Okay, the defense may call their next witness, please.
Yes, Your Honor. The defense calls Nat Romanov to the stand.
Okay, Mr. Romanov?
Yes, Your Honor.
Ms. Romanoff, I'm sorry. Okay, you are previously sworn. You may proceed.
Please introduce yourself to the jury.
My name is Nat Romanov.
Ms. Romanov, tell us, what is it that you currently do for a living? Are you working or in school?
So I'm still in school. I'm just finishing up my senior year at Steelton Tech. I plan to graduate with my degree in history.
That's very exciting. Do you have any plans after graduation?
I do, yes. After I graduate, I have a job lined up in DC.
Congratulations.
Thank you.
Ms. Romanov, I'd like to talk to you about the accident involved in this case. But first, can you tell me, do you know the defendant, Mr. Darren Ryan?
I do.
And how do you know Mr. Ryan?
Well, we're friends. We met at orientation when I was still going to Steelton Community College before I transferred, and we were roommates.
Do you believe your friendship with Mr. Ryan will get in the way of you telling the truth today?
No, I don't.
Objection, bolstering the witness.
Response?
I'm happy to move on, Your Honor.
Okay.
Ms. Romanov, going back to September 4th, 2017, starting from the very beginning, tell us, what do you first remember about that day?
Well, I remember that it was a holiday because we didn't have class that day. And some friends and I decided to go check out this new cantina that I'd opened to hang out, get some food.
You said some friends and I. Do you remember everyone who made those plans?
I don't remember everybody in particular, but I do know that it was me, Darren, and then a friend of mine that I was going to introduce to Darren.
Why did you want to introduce this friend to Mr. Ryan?
I thought they might hit it off. My friend had just started his own business, and from what I know about Darren, I thought he might be interested.
Did you confirm with Mr. Ryan prior to setting up this arrangement or meeting whether or not he would be interested?
No, I didn't.
Ms. Romanov, going back to the time, back to when you were all at Montana Max's, what time did you all meet up at the restaurant?
The plan was to come at 5 o'clock, and because my friend had to leave at 5:30.
Was everyone able to get there at 5 o'clock?
No, Darren was running late.
Did you try to get a hold of Mr. Ryan when he wasn't there at 5?
Yes, I did. I called him, but he didn't answer, and that's how I knew he was driving because he never answers the phone when he's driving.
Objection, speculation, and motion to strike.
Lay your foundation, counsel.
Yes, Your Honor. Ms. Romanov, after, in between the time period before Mr. Ryan arrived to the restaurant, what were you doing?
I was just hanging out, catching up with some friends.
And what did you do when 5:30 came around?
Well, my friend had to leave at 5:30, so I went ahead and walked him out, and that's actually when I saw Darren driving down the street.
Did you do anything at all when you saw Mr. Ryan driving down the street?
Yes, I waved at him, and then all of a sudden, a motorcycle pulled out in front of him.
Objection, non-responsive, motion to strike.
Okay, it's sustained as to the non-responsive portion, motion strike denied.
Ms.
You may
Romanov,
proceed.
thank you, Your Honor, my apologies. Ms. Romanov, when you waved at Mr. Ryan, do you know, did he indicate in any way that he saw you, that you know of?
I mean, I thought I saw him look in my direction, but he could have been, looking for parking spaces, so I can't say for certain.
Okay, I want to talk about the actual accident. You said that the motorcycle pulled out in front of Mr. Ryan. Is that what happened?
Yes, I heard revving noises and then there was screeching. When I looked back, I saw the motorcycle was on its side in front of Darren's car in the street.
When you heard those revving,
Objection, lack of personal knowledge.
I'm sorry, I didn't hear your whole answer, Ms. Romanoff. Would you repeat it for me, please?
Sure. So at that time, I heard revving noises, I heard screeching, and then I looked back and I saw that the motorcycle was on its side in front of Darren's car in the street.
Okay, that is overruled.
just to be clear, Ms. Romanov, did you actually see the motorcycle move?
Well, no, I didn't actually see it move, but like I said, I heard it, the engine revving. It was very close to me. And then I heard screeching as if Darren's car was braking as it was arriving.
How did you know that the revving came from that motorcycle? Was there a place it could have else come from?
I mean, there wasn't a lot of traffic that day, so there weren't a lot of, people on the street.
Ms. Romanov, when you were first at the restaurant, did you notice the motorcycle parked out front?
I didn't notice it until after the accident.
And after the accident occurred, where was the motorcycle located as you remember it?
It was in front of the car in the middle of the street.
Ms. Romanov, without getting into any details about specifics, do you know if Mr. Ryan suffered any injuries as a result of the accident?
Objection, lack of personal knowledge.
Okay, lay the predicate if you can.
Yes, Your Honor. Ms. Romanov, did you see Mr. Ryan after the accident?
I did, the next day.
And again, without getting into any of the details, from your personal knowledge, do you know if Mr. Ryan suffered any injuries?
Yes, he did.
No further questions, Your Honor. We pass the witness.
Okay, Mr. Guerrero, cross-examination.
May I proceed, Your Honor?
Yes.
Ms. Romanoff, you've been friends with the defendant for several years now, right?
Yes, it's been a few years.
The two of you met as freshmen at Stilton Community College,
That's right.
and you were even roommates.
Yes.
And the defendant helped you pay rent pretty often?
Objection, Your Honor. Relevance. May we approach?
Certainly.
Your Honor, we would object to the relevance of whether or not Mr. Ryan paid rent or helped in any financial way with Ms. Romanov. There has been no evidence, and we anticipate that the defense will not be, or plaintiff will not be able to offer any evidence about how much this rent happened, how many times it occurred, or whether or not it was just $10 to cover that rent. And so not only does that make it irrelevant, we'd also raise that its probative value is substantially outweighed by its prejudice.
Okay. Response, Mr. Guerrero?
Your Honor, defense counsel opened the door to this line of questioning by questioning the witness about her relationship with the defendant, whereas the witness testified that the two were roommates. So this line of questioning is just building on that after defense counsel opened the door to it. Further, this line of questioning will show the bias of this witness and any improper motivation for testifying here today. And credibility of a witness is always relevant, Your Honor.
Okay, it goes to the bias and prejudice of the witness. The objection is overruled. You may answer the question, Ms. Romanoff.
I'm sorry, could you repeat the question?
Sure. So, and the defendant helped you pay rent pretty often, right?
I mean, he did a few times, yeah.
When you couldn't afford it every month?
Yes, I'm embarrassed to admit that sometimes I needed help.
And the defendant never asked for that money back?
No, he didn't.
So the defendant is a really good friend.
I'm sorry, was that a question?
Yes.
Yes, he's a good friend.
And you would do a lot for the defendant.
Sure.
Now, you and the defendant were supposed to meet and hang out at Montana Max, right?
Right.
You were going to introduce him to a friend you had.
Right.
But this friend had to leave at 5:30 sharp.
Correct.
So the defendant was supposed to be there at 5 in order to meet your friend.
Sorry, who?
The defendant was supposed to arrive at 5 in order to meet your friend.
Right, we had plans to meet up at 5.
But he didn't get there at 5, did he?
He did not, no.
He was late
Yes, he was late.
because he's always running late.
Objection, Your Honor. This question calls for speculation.
Play the foundation.
I'll move on, Your Honor.
Objection
Now,
will
at the time-
stay.
Now, at the time of the crash, you just left the restaurant to walk your friend out.
Yes,
And because Darren had not arrived prior to then, right?
right.
And you saw him as you were walking your friend out.
I saw who?
You saw the defendant
Yes, I saw Darren driving down the street.
and you waved to him.
I did.
And you saw him look at you as you stood on the sidewalk.
Yes, I think he briefly looked in my direction.
So he took his eyes off the road.
Objection. This question calls for speculation.
Sustained.
Now, Miss Gray's motorcycle, you never saw where it was parked prior to the accident.
No, not before.
And you never actually saw her motorcycle move.
No.
No further questions. I pass the witness.
Anything on redirect?
Brief redirect, Your Honor.
Okay, proceed.
Ms. Romanov, on cross-examination, you were asked about Mr. Ryan lending you money. Can you tell us more about that situation?
Well, sometimes I was a little bit short on rent, and in order to help me out, Darren would offer me some money sometimes.
You were asked if whether or not you would do a lot for Darren, and you said yes. What do you mean by that?
I mean that we're friends, so we have, a mutual relationship where, he helps me move, I help him move, things like that. Things that you would do in a normal friendship.
Does the fact that Mr. Ryan lent you money a few years ago mean that you would lie under oath today for him?
No, I wouldn't risk my future for that, no.
No further questions, Your Honor. May this witness be excused.
Yes, Mr. Guerrero, may the witness be excused?
Yes, Your Honor.
Okay. Ms. Romanoff, you're excused. Thank you so much. Okay, Ms. Luckett, you may call your next witness.
Your Honor, at this time, the defense rests.
Okay. Anything further on rebuttal from the plaintiff?
No, Your Honor.
Okay, so we can proceed to closing arguments. Who will be closing for the plaintiff?
Your Honor, prior to closing arguments, may I make a motion outside the presence of the jury?
Sure.
Your Honor, at this time, the plaintiff, as a counter-defendant, moves for judgment as a matter of law because the defendant has failed to provide sufficient evidence such that a reasonable juror could find in his favor. Specifically, the defendant has failed to provide sufficient evidence of Ms. Gray's breach of any duty owed to the defendant and causation for the defendant's injuries.
So you're moving on their counterclaim, is that correct?
Yes, Your Honor.
Okay, response?
Yes, Your Honor. As to whether Ms. Gray breached her duty, I think we've satisfied that burden beyond beyond it being more likely than not true. Ms. Gray operated her vehicle, moving it forward as evident by the officer's drawing. She was also not wearing a helmet, which was a violation of Steelton Motor Vehicle Law. She had an unregistered vehicle, which is a violation of the Steelton Motor Vehicle Law, and she was not wearing a helmet, which is also a violation of this law. we have satisfied our burden that Ms. Gray actually breached a series of duties on that day, and due to her breach of duty led to the injuries of both her and Ms. Ryan.
Okay, so you're basing your entire counterclaim on the fact that it wasn't licensed, she wasn't licensed, she wasn't wearing a helmet, and what other breach did she make?
Your Honor, the primary breach was was driving the motorcycle. And because she moved the motorcycle, she was also in violation of 3 Steelton motor vehicle laws. The first being not having a valid driver's license, the second not having a registration, and the third being not having a helmet on.
The motion will be denied. We can now proceed to closing arguments. Who will be closing for the plaintiff?
I will, Your Honor.
Okay, Mr. Guerrero, you may proceed.
Your Honor, may I reserve 3 minutes for rebuttal?
Yes,
May it please the court.
certainly.
Be alert, because accidents hurt. No one knows that better than Miss Gray. On the day of this crash, the defendant was running late. When he was supposed to meet his friends at 5, he was still at home. Didn't even leave until 10 minutes later. And by the time he finally arrives to meet up with his friends, Nat's already walking out the door. He sees this because he takes his eyes off of the road and looks at her as she's waving by. That's when he flew into my client, Miss Gray, as she sat on her motorcycle. Now let's remember the weather conditions on that day. It was clear and sunny. There was even plenty of parking on the street. The defendant should have been slowing down to park. Yet somehow he still crashed into Miss Gray. She was then left injured. There was blood everywhere. Now, why did this collision happen on a clear and sunny day on a street with plenty of parking, a street with lighter traffic than usual, a street the defendant was familiar with and had been to since he was a kid? Because the defendant was in a rush. And in that rush to meet his friends, he did not act as a reasonably careful person would. That is negligence. The defendant had a duty to act in a reasonably careful manner to avoid injuring others. And now you, members of the jury, get to decide whether he did that. But again, the evidence today has shown that he was negligent. Now, as you may recall, our case must be proven by a preponderance of the evidence. This is just a legal phrase that means we must prove our claim to you. We must prove that our claim is more likely true than not. And you can visualize this term by imagining a balanced scale with 2 pans on each side. On one side, you'll put the evidence favorable to the plaintiff, and on the other, the evidence favorable to the defendant. Now, if this scale tips even slightly in favor of Miss Gray, you must find for Miss Gray. The judge has already instructed you on the law, and when you go back to the jury room to deliberate, you're going to be given a verdict form. Your Honor, may I share screen?
Yes.
Can the court and jury see my screen?
Yes.
The verdict form. So for question 1 on this verdict form, was Darren Ryan negligent by a preponderance of the evidence? That again simply means, is it more likely true than not that the defendant failed to act as a reasonably careful person would? Now the answer to this question is yes. The defendant was running late and in a rush to meet his already leaving friends. He's supposed to be there at 5, still at home. Gets there 30 minutes late as his friend is leaving and waving goodbye. And on this familiar road that he had been to plenty of times, He's not focused. He's not being vigilant. He's not thinking about carefully parking. Because he then takes his eyes off the road right before flying into Ms. Gray. He should have been focused on driving carefully and on slowing down to park his car. For question 2, was the negligence of Darren Ryan a factual cause of harm to Ms. Gray? The answer to that is yes. After this collision, Ms. Gray told us that she was injured. Our witness said there was blood everywhere. Her injuries were caused by the defendant. Question 3, was my client negligent by a preponderance of the evidence? The answer to that is no. She wasn't drinking, she wasn't running late, and she wasn't distracted by friends on the side of the road or trying to catch up and meet with them. She was just sitting on her motorcycle when she was struck by the defendant. And to the surprise of no one here, the only person to claim that they saw Ms. Gray pull out into the street is the defendant. His own friend even admitted that she never saw the motorcycle parked and never even saw it move. She didn't see it, so she doesn't know. And with that, answering yes to questions 1 and 2, and no to question 3, you'll be done with the verdict form, and my client will be done with this ordeal. So please, hold the defendant accountable. Thank you.
Thank you, Mr. Guerrero. Mr. Ante, will you be closing for the defendant?
Yes, Your Honor.
Okay, you may proceed.
May I proceed?
Yes.
May it please the court. Be alert because accidents hurt. This is the motto that guides our roadways. It protects us, the citizens of Steelton. And it's the motto every good driver knows, because when the unexpected happens, someone may get hurt. Members of the jury, we represent Mr. Ryan, the defendant and counter plaintiff in this suit. Today, the plaintiff had the burden of proving to you that on September 4th, 2017, Mr. Ryan was negligent. As you were instructed by the judge, negligence occurs when a reasonably careful person fails to act in a reasonably careful manner. And this failure to act reasonably, as they were supposed to do, then leads to an injury. In other words, we must prove 3 things to you today. Number 1, that the plaintiff and Mr. Ryan owed each other a duty. Number 2, that the plaintiff breached that duty. And 3, that Mr. Ryan's injuries were substantially caused by the plaintiff's actions or lack thereof. Now, we welcome this burden, and I'm confident that today, unlike the plaintiff, we will meet our duty to you today. Ms. Gray and Mr. Stork have known each other for a long time. They rode motorbikes together at a young age. They worked together. Mr. Stork helped Ms. Gray get a job here. And Mr. Stork said everything that he thought he would need to say to help Ms. Gray out. But unfortunately for them, their stories just don't line up. And why is that? Well, maybe it's because Mr. Stork, as he testified, had a buzz going. He had been drinking for at least 2 hours. He had 3-4 margaritas and a couple of beers. Members of the jury, he was inebriated that day, and his inebriation impaired him from seeing the correct thing that happened. Now, Mr. Ryan testified that at the time of the accident, he had a seatbelt on, and he testified to slowing down, turning his blinker on. Ms. Romanoff testified to hearing the screech of tires and the rev of a motorcycle engine. And you heard every single witness here today testify that after the collision, the plaintiff's motorcycle was on its side in the street in front of Mr. Ryan's car. Now, Mr. Ryan also showed you in his drawing how the motorcycle pulled up in front of him. And the X that marks the spot can only be explained by a pulled up motorcycle. Members of the jury, Exhibit C, as you will see on the left, was drawn by the only objective and neutral person at the scene of the accident, with absolutely nothing to gain with this drawing. And as Mr. Ryan testified, Unit 1 is his vehicle and Unit 2 is the plaintiff's. If Unit 2, if the motorcycle had been stationary, as the plaintiff alleges, when Mr. Ryan and Miss Gray crashed, the motorcycle would have toppled onto the sidewalk. But where is that motorcycle? It's in the street. And the only reasonable explanation for that motorcycle being on the ground in the street is that it moved forward, that Miss Gray drove, she rode her bicycle forward. And this explanation can be seen with the arrows drawn by Mr. Ryan on his drawing. Miss Gray said she got on the bike because it was her dream to own a motorcycle. She wanted to, and I quote, feel the rumble of the motorcycle. She wanted motivation to pass this test this time. She was excited to get on the bike. And you heard Miss Gray testify that she wasn't familiar with this motorcycle type, Grandmaster Hurley. She wasn't planning on riding it, but that didn't mean she didn't do it. The only reasonable explanation is that Miss Gray, while on a running engaged motorcycle, put that Grandmaster Hurley in gear, riding it forward. As Mr. Ryan slowed down to enter that parking space in front of the motorcycle, Miss Gray drove the motorcycle right into the street and the vehicles collided. You heard evidence from both the plaintiff and Mr. Ryan that they were seated and in control of two running vehicles on Webster Street on September 4th around 5:30. And as operators of motor vehicles, they owed each other a duty, as well as a duty to motorists and pedestrians nearby. It's undisputable that this incident occurred on Webster Street. And the rules and regulations of the road in Steelton govern this case. The law requires vehicles to be registered, and therefore titled. And the law also requires that motorcycle riders possess a valid motorcycle license. And for riders of less than 2 years to own and wear a helmet. Not only did Miss Gray drive her motorcycle forward, she violated all of Steelton's laws. She breached every duty to a motorist out there. And yet at the beginning of this trial, the plaintiff had the audacity to tell you that Miss Gray did everything right? If we can't trust a motorist to file the correct and timely paperwork, then we sure can't trust them to follow the rules. If the plaintiff had followed the rules, if she had followed Steelton motor vehicle laws, there would have never been an accident. There wouldn't have been any injuries, and we wouldn't be here today. Now, negligence is measured by a reasonably careful person standard. And I want you to consider the following questions. Would a reasonably careful person sit on a running, unregistered motorcycle in the street? Would a reasonably careful person sit on a running, unregistered motorcycle in the street without a motorcycle driver's license? Would a reasonable, careful person sit on a running, unregistered motorcycle in the street parallel to moving traffic, not only without a driver's license, but without a helmet? No. A reasonably careful person wouldn't do that. Why? Because it's illegal, ladies and gentlemen. And it's illegal because it's reckless. And it's reckless because it causes injuries. The testimony you heard today from all the witnesses is evidence that Miss Gray violated her duty to carefully operate a motor vehicle. Miss Gray was sitting on a running Grandmaster Hurley, and Mr. Ryan was in a small, compact Ford Focus. Miss Gray didn't know how to operate that bike. She put it in gear without knowing, and she breached her duty to control her vehicle. Now, Miss Gray not only moved her vehicle and breached Steelton motor vehicle laws, she wants to place the blame and the responsibility on Mr. Ryan. That's not responsibility. The evidence shows it's more likely than not true that the plaintiff moved her vehicle. And this caused Mr. Ryan's and her injuries. You heard Mr. Ryan testify that he was aware of the weather and the traffic on that day. And you heard Ms. Romanoff testify that in her experience, Mr. Ryan never answered the phone while driving. And on that day, she called him and he didn't answer. Mr. Ryan fulfilled his duty to observe conditions of traffic and weather on that day. You also heard him testify that he put on his blinker and he slowed down to pull into a parking space. He fulfilled his duty to not drive at an excessive speed. And while Mr. Ryan was slowing down, he signaled to other drivers, warning them that he was turning into this parking space. He also testified to having a valid driver's license, and he had a seatbelt on. He fulfilled his duty to follow the rules of the road. Finally, you heard Mr. Ryan say that he slammed on his brakes the minute he saw Miss Gray ride forward in her motorcycle. Mr. Ryan did his best to avoid an accident. And more importantly, he fulfilled his duty to operate the brakes of his vehicle. Mr. Ryan fulfilled all of his duties as a motorist on the road. He never breached a single one. And because he didn't, he cannot be found negligent today. Now, yes, Mr. Ryan is young, and the plaintiff wants you to think that because he's a young male, then it's more likely than not true that he was reckless. But the evidence is clear. He slowed down. He grew up here in Steelton. He knows the street, he knows the rules, he knows the law. He didn't care he was running late. You heard him say he didn't need to meet anyone. Mr. Ryan was not rushing that day. Mr. Ryan was just a young teenage guy getting ready to experience college. I mean, how many teenagers do you know ignore their phones while they're driving? Not many. And why is that? Well, it's because not many teenagers have lost their parents in a motorcycle vehicle accident. Mr. Ryan is a responsible young man who at his young age, he has been marked twice tragically by motorcycle collisions. Now, and first, when a motorcycle took his parents away from him. And this tragic event in his young life cemented in him the motto we've told you since the beginning, and the motto that every good driver knows. Be alert, because accidents hurt. Members of the jury, when you go back to your room and you're presented with the verdict form, you will fill it out as follows. When asked, was Darren Ryan negligent by a preponderance of the evidence? You have to say no. And then you will jump to question number 3. Was Carson Gray negligent by a preponderance of the evidence? It's more likely than not true to be a yes. Was the negligence of Carson Gray a factual cause of any harm to Carson Gray? Yes. Members of the jury, when you go back to jury deliberations, you will come to the only answer that the evidence supports and that justice demands. Thank you.
Thank you, Mr. Rodte. Mr. Guerrero, Roberto?
The defendant wants this case to be complicated. The defense wants to be nitpicky about the title to the motorcycle, Steelton law, who turned on the motorcycle, to try to confuse you. But that doesn't matter. The title paperwork doesn't matter. Which one of them turned on the motorcycle doesn't matter. What matters here are the actions of the defendant. Do we believe the defendant was actually slowing down with his signal on if he slammed on his brakes? And is that why he suffered a concussion and broken neck bones? Because of how slow he was driving? Do we believe he was paying attention if he slammed on his brakes? Do we believe he was driving carefully if he slammed on his brakes? Do we believe he wasn't in a rush if he sees his friend waving bye to him as he arrives? Now, you also heard the defendant's friend, Nat, say that she heard the revving and screeching, but she even admitted that it might have come from another source. Miss Gray's motorcycle was on that road, but so was the defendant's vehicle. The defendant's vehicle that was traveling so fast that he slammed on his brakes and suffered injuries himself. The defendant's vehicle that was traveling so fast that when he struck Miss Gray, her motorcycle flew into the street. The defendant was in a rush. He was running late and flew into my client. So I urge you to consider all of that evidence and the testimony of our witnesses and return the only verdict that the evidence supports and that justice demands. Hold the defendant liable and give Ms. Gray the justice she deserves. Thank you.
Okay, well, that's a wrap. It now goes to the jury. Thank you all so very much. You did a great job. Judge Weems tells me that this is like the 4th or 5th time that you've done this weekend. Perseverance. I don't know if I could do anything that well after having done it 4 or 5 times previously. So you all did a great job. You are to be congratulated. Congratulations. Nice work. I appreciate very much having the opportunity to have sat and judged the mock trial. You all did great. Thank you, Judge Weems, for inviting me.
Absolutely. So what I would actually love to have happen next is if I could put the 5 judges into a breakout room. All I need for you guys to do is have a little bit of discussion and then just vote. With 5 of you, there's no way there's going to be a tie. One team will win. So just decide who you think won the round. But I'm going to put you in a breakout room to do that so that we don't have to sit here and awkwardly watch you while you do that. So just give me 1 second. You'll receive an invitation to go into a room and please accept it.
Will you be joining us, Judge Weems?
I'll probably pop in just for a second.
Okay, thank you.
All right. And then so students, pat yourselves on the back. Congratulations. Super proud of how well y'all did. I know Emily's like, I got this. I can totally pat myself. And then Robin, you should have received an invitation to go into room 1. There we go. I'm going to go jump in with them real quick. So y'all just hang
Judge
tight.
Weems, I have a quick question. Are we going to continue the stream or?
Yes. So you may want to just take yourself off for a second, unless you want to talk and have people see what you're saying. Just be mindful. We had at one point like almost 20 people watching. So, you know.
Live is the best thing that's happening during COVID right now.
Right, watching y'all try around. All right, I'm gonna go join the judges real quick.
Well, I don't mind everyone out there on YouTube seeing this, but great round, y'all. Really great job.
Yes, congratulations to everybody being here because obviously we did a good job. So congrats, Stefan. It was great to see you again.
Yes. Maybe we'll be working together again this semester.
Maybe.
As teammates rather than competitors.
Yeah, I would like that.
Amy Jo Foreman just asked me to tell everyone that her and Derek watched. They had such a good time and everyone did capital S-O so good. So I just wanted to share that with all of you.
Okay, we are back. So if all the students can pop back on. So I'm going to, since this is an actual tournament problem for AAJ, all of 5 of the judges have graciously agreed to give you some feedback on your performance, since all of the tournaments are also going to be on Zoom. There's a lot we can all learn, and then give you some feedback on the problem. And then I'm going to announce who wins. So you're going to have to wait. So whoever wants to go first, please feel free. I'm going to mute myself and stop video and wait till you're done with your critique and feedback.
Hey, Judge Weeds, I'm going to jump in and go first because I'm going to have to exit when I'm done. I have another commitment that I need to take care of. So if the other judges don't mind, may I go first? Okay, I appreciate it. I'm just going to hit a couple of things. When you're on Zoom, this is something that we see even in the courtroom. Okay, you really need to pay attention as to what's in your background. Okay, and the fact that some of you are in your bedroom with the bed in the background is a real problem, and it's a distraction. So I would pick a blank wall if I had to and get a TV stand and put your laptop in front of you with the blank wall behind you before I would appear on Zoom with the bed in the background. You know, I think it was Ms. Lukat who made the attempt at impeachment. I thought if there was objection to that, I probably would have sustained it. When you are impeaching someone, you need to make sure that you ask the exact question that you are getting ready to impeach them with. What you impeached with was not what was really answered in the deposition testimony, and I would have sustained an objection to improper impeachment. Never shut off your video camera before the judge dismisses either the witness or you. A couple of times y'all had to come back on to the video because I had asked another question and you had already signed off. So you should always wait until the judge says it's okay to go. And there was the kickstand issue. I think somebody missed something really big on the kickstand issue. I think it was you, Ms. Lukat, and I might be wrong, but was cross-examining the plaintiff and wanted to talk about taking the kickstand off. And if another witness says that you had taken the kickstand off, Mr. Stark said you had taken the kickstand off, would you have taken the kick, did you? And then when Mr. Stork testified, nobody asked him, did you take the kickstand? Did you see her take the kickstand off? I kept waiting for him to say she took the kickstand off. And so you set it up, even though I don't think I let you ask it, but you did set it up and then it needed to be brought home and it never was. Somebody said just a kid, Durant, I think that was you. Ms. Gomez-Durante, you mentioned just a kid. I don't see really any reason for that. The O on the diagram, and I don't know what this really does, but the whole time I'm thinking, and I'm telling you, it's what's distracting you from what you're saying. What does O stand for? When you had him mark the O, where on the diagram, your witness on the diagram, you had him do MM for motorcycle. Okay, MC is probably better for motorcycle, but I kept going, what's the O for? Did it have a meaning?
It was just to denote that it was empty, but I will change that going forward.
Okay, I would just put it something though. With regard to Mr. Guerrero, motion to strike, motion to strike, motion to strike. You only move to strike if it's just killing you. Otherwise, the only thing you're doing with a motion to strike is making sure everybody knew it was bad for you. So, I mean, motion to strike is appropriate if it's really hurting you, but if it's just something you just need to move on, objection sustained, move on. It's done. Okay, you all need to learn how to lay a foundation because there were a couple of things that you all talked about that I thought you could have laid a foundation for. Something about him not answering the phone. I think Ms. Ravanoff was talking about that he didn't answer the phone when it rang in the car. So the foundation would have been, have you driven with the defendant before? While you were driving with the defendant, did the phone ring? What did he do? Did you do that few or many? Did he do that few or many times? Then you have established that you have knowledge of the fact that he doesn't answer the phone when it rings. A similar situation was with him being late, okay? That he was always late. Is he always late? Well, the objection was speculation. I said lay the foundation. Have you on few or many occasions met with the defendant or had to wait for the defendant for him to appear at a public place to meet you? On few or many, and is he generally on time or did you find him to be late? That would have laid the foundation for the testimony. He's always late. Okay, so I think that this problem contains a lot of red herrings. I think that many of you jumped on. Okay, for instance, no driver's license in the real world, and I don't know if you can move for this as the plaintiff, that's not coming into evidence. That doesn't show negligence of any kind. It doesn't show that there's a breach of the duty. So if you are representing the plaintiff, limiting should include the fact that they don't have a driver's license. The title, ownership is not in dispute of the motorcycle, that she owned the motorcycle at the time. Nobody said she didn't own it. Okay, she owned it and gave it to Stark to drive. Ownership wasn't an issue. The title, I mean, again, I would move, if you're the plaintiff, I'd move the limited out. It has no relevance to the duty, the breach, or the proximate cause. I also might take a stab at limiting out the helmet issue if you're the plaintiff. With a bifurcation issue, because if I were arguing, I would say that the helmet goes to the issue of damages, especially since she had a closed head injury. But this is a bifurcated case. What does her wearing a helmet have to do whether there's a duty or a breach of the duty? So I would take those three issues right out of the case. I think they're red herrings, okay? And I would take them right out in limiting if I'm representing the plaintiff. If the helmet came in, defendant said something that I thought that was interesting, that he didn't think she was going to pull out because she didn't have a helmet on. I might, if the helmet is coming in, establish with the plaintiff that I don't put the motorcycle into gear unless I have my helmet on. And then when the defendant says she didn't have the helmet on, I didn't think she was coming out into traffic, you've then gotten the defendant to establish she wasn't moving. Okay, in rebuttal argument, okay, and this is a matter of style, okay? I'm looking for Mr. Guerrero. In rebuttal argument, okay, don't repeat what the defendant said. Use rebuttal to give your last closing shot for the jury. You repeated what she said in argument. You took your rebuttal and repeated what she said. I would never do that. And just so you know a little bit about my background, I tried car wreck cases for about 30 years before I took the bench. So I've tried a bunch. So that's kind of my background. I thought you all did really, really well. Stamina is a big part of this, especially on a Sunday night at 5:30 after having done it 4 times. And I really commend you all for having done a great job. As I told Judge Weems, I asked to go first because I need to move and be somewhere by 6 o'clock. Interestingly enough, these times turn out to be the same as Mr. Ryan, 5:30, 6 o'clock. And so I don't want to be late. So I am going to be signing off. Congratulations to you all. I wish you all good luck. I understand that this is a problem you all are going to be competing with, and I'm sure that Judge Weems will give you lots of good information going forward. Yes, ma'am. Did you want to talk with me?
I just want to say thank you so much, Judge Roth, for taking your time coming up to the courthouse so they could have an authentic experience of you on your bench with your robe on, because I know they never get that with me.
Very sweet.
But thank you so much, Donna.
Anytime, Judge Weems. You all have a great evening.
All right. Who wants to go next?
Bye.
Robin, would you like to go next?
Well, I'm going to pass the baton first to one of my colleagues here because I'm afraid that I might use up all of the time otherwise. And I do want to give everybody else a chance as well. And then with remaining time, I can skip through any comments that haven't been covered, if that's okay.
I'll jump on.
Don or Colin?
Colin, you ready, or I can go? It doesn't matter.
Sure, I can go. Great job, everybody. I just have a few notes. I guess I definitely agree that there was a lot of emphasis on these kind of minor violations, like the license and the title. I think just who cares about that? I just don't think that that was very persuasive. And so, you know, the helmet, maybe, but the title, I don't know. I just would not focus on that as much. There was also, I felt like, a lot of focus on the fact that it was a nice day out, and then the fact that it happened on this particular street. And I get why the nice day was, I get why you brought that in, but I just heard it repeated a lot. And so, I mean, I think you can say it once and it doesn't need to be mentioned multiple times. And yeah, I guess the street was to establish that these traffic rules apply, but you know, same thing. I think you just establish it happened on the street once and be done with it. I don't know if it's expected to move for a directed verdict in these, but you know, I thought this was pretty clearly a case where, I mean, it wasn't going to work. So you know, if you're expected to do it, I guess you do it. But I don't know. I just thought that, oh, I understand that they're going to try, but I know it's not going to work. Another thought I had was, I don't know if if the defendant has to make his counterclaim, but I mean, I thought that was one of the biggest problems was that the defendant had to say that he was driving and slammed on his brakes and got hurt that way, but then also had to testify that he was driving slowly. And so I thought that really hurts his credibility. So I don't know, maybe consider not even bringing the counterclaim. Just a thought I kind of came up with off the top of my head. And then I don't know if you can like stipulate to injury in these cases, but that might be another way to get some of those issues out. Because like I said, I thought that was kind of a problem for the defendant having to talk about getting injured in that way. But those are my thoughts. And great job, guys. I'm really impressed that you've done this so many times this weekend.
All right, I'll jump in. First off, whatever Robin tells you, take it to heart and do it. He's one of the best trial lawyers I've ever worked with, and I mean that honestly. He's awesome. He's done it way more than I have, and he's terrific. I'll jump in on a couple of points. First off, with the deposition, set up the depo. You know, you had your deposition taken, right? You promised to tell the truth, the whole truth, right? And when you were deposed, I asked you the same question, and you said something different, didn't you? Then go into it. You got to set up the depo. You kind of leaped into it without some of the foundation that's going to be necessary. Objections. Make sure you know the rule cold, okay? Judge Roth invited explanation about how the federal rule works on bringing in a report. And I thought, Ms. Gomez-Duarte, if you would have explained to her, well, Judge, here's the rule. Here's what this rule is. Here's what it says. And here's why I think it comes in. Because it's different than Texas. And she was thinking the Texas rule, you could have explained the rule. So, it says this, and here's why I think it comes in a little better. Don't object just because the evidence hurts. Say, oh, I didn't like that. What's your objection? It hurts. Relevance. Think about that. It's because it looks like you're just pointing out a weakness in your case. Oh, that stung. So think about those objections. Know the rules cold. Be prepared to have the other side's objection granted, and you just got to be able to tilt and think on the fly about another way to get a fact in, even if the judge's sustaining of the objection is wrong. It can really throw you for a loop. Whenever those rulings are done, just let it go and move on to the next thing. I know that really kind of threw you off a little bit. It happens all the time. Don't worry about it. You're just going to need some more practice, but just move on. They sustain the objection, just move on, find another way, or circle back to it afterwards. The impeachment, it didn't go so well. You got to make sure, number one, is it worth impeaching them on? Is it a material fact? I thought the significance about the dirt bikes were, number one, it's completely different than this giant hog she just bought. So talking about whether they're similar, who cares? I'd emphasize they're completely different. You didn't know what you were doing on that thing. In a he said, she said case, you need to think about what facts can I put up that are going to make my story seem more credible. A couple of things jumped out to me. The plaintiffs left a lot on the playing field. The defendant had been a careless driver before. He just had. You don't need to worry about the police report or how you're going to get that in. Look, let him impeach himself. You're just not a very careful driver, are you? Oh, no, I'm great. Well, no, actually, you're not, are you? You've actually had instances where you've been careless. Oh, yeah, no, I've never been careless. Bam. So I thought the careless driving was significant. In the closing, you hit on the fact that if you're slowing down to get in a parking spot, you're not going to get whiplash when you hit the brakes. You could have brought that up in the cross. Oh, you were going slow, but you were going so slow you caused yourself whiplash when you hit the brakes, right? The witness is not going to be able to explain that. You waited till the end of the closing, which was fine, but I think you could have brought that up with a witness. Tell the story with your witness. Let your witness tell a story, You had one instance as a lead on the plaintiff side with your direct witness. It happens. I thought, Mr. Arte, you did a good job on your direct, letting the story kind of unfold. What happened next? And get a good story going. Get a rhythm with your witness. It just seems more credible. If you just, make me interested in your witness. What I thought about the helmet was the comment, and you really got to know your record because you never know quite how it's going to unfold, and you got to be able to pounce on things as they happen. When the witness said, well, I didn't put my helmet on because I wasn't going to drive, and if I was going to drive, I'd have had a helmet on. Oh, really? So you've never driven a motorcycle with your helmet off before? No, I think the significance was it didn't matter. She was going to drive that thing anyway without a helmet on because she had done it before. I would have jumped on that and I'd have brought that point as soon as she says, I wasn't going to drive. I didn't have the helmet on. Oh, yeah? Really? That's interesting because you've actually been cited for doing that before. That was within your character and the way you drove. It occurred to me, if I'd have just bought a brand new, fancy, expensive dream motorcycle, I'm sure not going to park it and leave it in front of a bar overnight. How's that bike going to get home? Mr. Stork was drunk. He said in his depo, I had no intent of driving it. You didn't live next to that thing. You lived on a different street, clearly. You going to take that brand new, beautiful bike and leave it in front of a bar? That seemed odd. How was that thing going to get home? She intended to drive it home. So that jumped out to me. Be alert as a defense motto was horrible. Your client wasn't alert. He was looking at somebody else. That just sort of I would have pounced on that if I was a plaintiff. Oh, be alert. Well, that's funny because that's exactly what happened here is he wasn't alert. You're not accusing the plaintiff of not being alert. The plaintiff was lying and the plaintiff lurched out into the street. She was excited about getting that new bike. She, you know, pick a motto that picks that up. The be alert is really what the plaintiff should have said. You got to be alert. And this guy wasn't alert. He's staring at his friend waving at him at the precise moment that the accident happened. So I didn't like the slogan by the defense. Other than that, I sound like I'm being hard on you guys. But, you know, I thought you did a good job. So that's it. I'll turn it over to the next commentator.
Okay, well, I guess that's me. Good job by everyone, and good endurance, having gone through this, I guess, 5 times since Friday evening. I also want to say good job to the witnesses. These are always fun to watch, and to watch people's acting skills. And I thought the witnesses all did a good job as well. So, and I know that you're volunteering, I assume, your time as well. So congratulations to all of you on a good job. I made a bunch of notes just as the trial went through, like maybe a juror would, but these were more sort of style points. So I'm going to go through them kind of quickly. Some have been touched on. And I'm going to give you my framework, and that is that once I knew what this case was about, I figured this was going to be a case where a jury could likely divide proportionate responsibility between both the plaintiff and the defendant. In my own thinking, I did that. I gave some negligence to both parties. So in the openings, my note on Mr. Sanchez is that I, as a plaintiff, I never emphasize the fact that I have the burden. Now, in closing, your team did a good job of sort of lessening what that burden really is, but I wouldn't take that on as the plaintiff at the front end. No need to. It just makes it look like you've got maybe a higher hill to climb because you haven't really explained what it is. And take my word for it, jurors never get it anyway. They just don't. They decide who wins and who loses, and it's rarely, you know, which scale has tipped or whether somebody got it over the 50-yard line or any one of those many illustrations of the burden of proof. But I wouldn't take it on in the opening, at least. And my question, my note here, and I can't go back and recall particularly, but I was sort of wondering, and this in a negligence case I've learned is really important. You have to identify what that negligence was. And then you want to just stay focused on it laser-like throughout the trial. Like Colin and John have said, and the judge as well, there are a lot of distractions in the record here that you may sort of think, well, it's in my case example, and so I have to speak to all this stuff. But that's not what good lawyers do, especially good plaintiff's lawyers. They seize on 1 or 2 things and they just won't let go of it. And it's sort of one of the ways to think about it is, what are the jurors when they hear this case? And think about this with every case. What are the jurors going to say? I just can't get over fill in the blank. All right. And for me, in this case, it was, I just can't get over that motorcycle was in the middle of the road or close to the middle of the road. How does anybody explain that? It's there. So how did it get there? Well, it didn't get there on its own. There might have been something in the record, and I'll concede I didn't do anything but skim the record very quickly before becoming a juror, which is more than your jurors will ever do. but so that's the I just can't get over this sort of point to be made. And all the other stuff, you know, you can mention, because some jurors will find something else really important. So it's not like you ignore the other facts necessarily, except for the real tangential ones. And what was that for the plaintiff? The plaintiff was, I just can't get over that this guy broke his neck when he was driving so carefully, going the speed limit, keeping his eye on the road while he waved at somebody that he saw without taking his eyes off the road, and was slowly pulling into, you know, multiple widths of parking spaces. How did he slam on the brakes, bash his head in somehow, and break his neck? That's going to put some negligence on the guy. So, you know, that's always a really important point in negligence cases, to really define for your jurors what the negligence was. Not a big laundry list of stuff, but the really key points that you want them fastened on. On Emily's opening, I have, let's see, good emphasis on the split-second nature of the accident, and a good preview of the evidence highlights. I think you did those things well. And this raises another sort of big picture point. In all cases, you have sort of a case vocabulary. And that is, how are we going to describe things? And you come up with those early in a case so that in depositions, you can start using that vocabulary, and you can start getting your witnesses, even the other side, maybe even the other side's lawyers, to adopt your vocabulary. And when you're on the flip side of that, you want to be sure that your people aren't adopting the other sides. So the plaintiff here wants to be talking about a crash, you know, come up with those words that make this sound like a big event. And the defendant wants to be referring to this as an accident or the incident or something that minimizes what you're talking about. And I saw that here the defendants were referring to a let's see, you know, I think they referred to a collision or something. Well, that's a little bit much. So you want to, again, take away from it with your vocabulary. And the plaintiff, I can't even read my own notes. One time used collision. Oh, I think barreling down the street might have been a phrase that was used. And those are good. Those are good words to be using when you're talking about the driver of the car there. Okay. All of you need to anticipate objections and how you're going to respond to them. It doesn't take a lot of experience, but it takes some to know that, okay, I'm going to be asking a question about a document that I may or may not be able to get in. How am I going to, what's my foundation going to be to get it in? And when the other side objects, what are my responses going to be to, you know, hearsay, prejudice, relevance, whatever they may ask, and anticipate and be ready for those in advance. I don't do it with all of my evidence, but I still, when I know I'm getting onto something that's a little bit touchy, I actually pencil into my notes why this is admissible and what my responses would be to different objections so that I'm ready for that. Because nothing makes you, well, not nothing, but it makes you look less competent and less trustworthy, less credible with the jury if you can't just, you know, quickly respond to things like that, you know, because then the jurors are, oh yeah, well, he's kind of a beginner. Or, yeah, I'm not sure that she is telling us the truth because she asked a question, the judge knocked her down and she didn't rebound from that. John's point about setting up the deposition is good. No juror knows what a deposition is. You know, we asked you questions before this trial. You were under oath. Your lawyer was sitting right there with you. You had a chance to read it and correct it before you came to court today. And with all of that, let's look what you said then. You know, there are all sorts of things you can do to dress it all up. Some people overdo that. But you have to explain what a deposition is, not just say, well, you said in your deposition. Well, you know, if they're big churchgoers, they're thinking about Jesus being taken off the cross. So explain those things a little bit more, and especially when you're using those legal words. Mario, you asked Tony, do you know why you're here? What if he'd said no? You don't. You do want to put in context your witness, but all the jurors know that you're calling the guy. He knows why he's there, and so you can introduce him in a different way. You can say, "Now, Mr. Stork, you were there the day that such and such happened, right? Yes, and you saw it happen, didn't you? And that's what you're here to testify about here today, right? Yes." And then so you've set them up, you've given them a little credibility, you've made them a real witness. Yeah, those are leading questions, but anybody lets you get away with those sort of setup leading questions. And then in your direct, my note was, you know, and it applies to all of you, ask questions that paint a picture. Not just sort of name, rank, and serial number, nothing but the facts, ma'am, kind of thing. Think about how you're going to really paint what you want those jurors to see in their head, you know. And Mr. Stork, if you can have like 4 to 6 drinks and just have a little buzz going on, you know, more power to you. I wouldn't have been able to get out of the restaurant. So you asked, this is Ms. Duarte. I think you said, now, yes or no. You got kind of a flimsy answer, said yes or no. Some people interpret that as a little bit harsh. So there are other ways to go about, just repeat the question and say, you know, yes, like, oh, so maybe I didn't ask my question straight enough for you, Mr. Witness. So you didn't actually, whatever your question was, right? And then they'll shorten up. They're not going to volunteer the same thing to you again, typically. Let's see. I didn't like your sidebar once or twice. I think one time you said, oh, you're so caring or something. That was a little snarky. And another really big picture thing in the real world, jurors always sympathize with the witness and not the lawyer until the witness gives them a really good excuse to want the lawyer to whack them. So, you know, they're always sitting there saying, gosh, I'm glad I'm not that witness. I wouldn't want to be in that witness chair for the life of me. So don't jump or get snarky with a witness until they really give you license to do that. And you didn't have it there. And you did it again, you know, oh, you were just a kid, or, oh, I'm so sorry. With your own witness, like you're just finding that stuff out? Yeah, that was Ryan, right? Yeah. And you referred to, here's where I had another note about vocabulary, the crash, the collision. That's the other side's vocabulary. Let's see here. Really good handling of the objection on the, Ms. Duarte, really good handling of the objection on the accident report. That's how you want to handle objections. You know, you had the rule, you had the rule in mind, you knew how to deal with it. The judge asked, well, does it have to be certified? that kind of threw you off, but frankly, it threw me off a little bit too, because authenticity was stipulated too. But maybe there's a part of that rule that I'm not thinking of, but you had anticipated those objections and did a really good job in responding to them. Mr. Sanchez, on your cross-examination, some of your questions were a little repetitive because the witness jumped ahead and sometimes said, well, I can't remember what it was. Well, it was a sunny day and blah, blah, blah. And you said it was a sunny day, wasn't it? I don't think that was what it is. That's an example. But so you have to listen to the witness's answers. And if he's gone ahead and given you information that is on your outline a little bit further down, well, you have to adjust to that. And you can go back if you think it's an important point. Now, earlier you said da-da-da-da, rather than asking it, because the jurors are all sitting there saying, well, you already said that. So you have to have a little flexibility in your outline of questions. Foundation issue, let's see, now I'm over to Emily. He never answers the phone. That's one that, again, if it's an important point, you want to be ready for it. And you asked, did Mr. Ryan suffer any injuries? And I think that you handled that one better. I've got good written beside it. Mr. Guerrero, good response to the objection to the defendant paid rent. I don't know if you'd prepared for that, anticipate you were going to get that objection in advance, but you handled it well. So that was another example of you all, in some instances, handling objections well. You did well on that one. You went one question too far, where you said you do that. He's a good friend and you do that a lot for your friend. And he answered the way you wanted him to, but a lot of the witnesses would have said, I'd never lie for any friend. And then that's when you've asked one question too many. So you have to know where to stop on those. Closing arguments. Yeah, that be alert because accidents hurt. I don't know who that. Let me ask: was that a theme that in the materials each side was supposed to use? Because both of you sort of used it. Those themes are, again, the really important part of a case where you want to frame up the case so that the facts fit your theme. And I'm not sure about that one, but I agree with John that it certainly wasn't helpful to one side. Mr. Guerrero, you did the closing. Again, the fact to me that was so important on your side was that this guy had to slam on the brakes so hard that he hurt himself. And you saved that for rebuttal. I don't know if that was intentional, but you should have, I would say, get that out there at the beginning of the argument and then pound on it some more when nobody can stand up and say anything else because you've got the last word. And so I was saying, sort of like you aren't talking about that. And to me, that was really the big important fact. And then Ms. Duarte. You did a good job with getting to the fact of the sort of, I just can't get over fact for me was the motorcycles out there in the road. And you did a good job early in your argument of hitting on that point. One thing for all of you, and I'm going to bring it up in Ms. Duarte's presentation because she did it really well. When you're on Zoom, when you're in the courtroom, of course, but when you're on Zoom, you have to use your hands. And Ms. Duarte says that one reason, two reasons, whatever it was. I thought she did a really good job of hand gestures. Now I'm seeing myself on this and it's like, oh man, the guy's got these hands all over the screen, but hers looked a lot better than mine. And another thing that she did, I think, well, was every once in a while for emphasis, and I don't know if it was intentional or just her way, she sort of leaned into the screen to make a point. And, you know, that's sort of Zoom style that I think is effective. And you have to think about things that are going to make you more than just a talking head. You know, you can't walk around the courtroom. I think Ms. Luco, you, I think, clapped your hands or something when you're saying a split second there was an accident. That's really good too. Those are the things we want to do in the courtroom. And on Zoom, you have to think of those things that make you a little bit more effective and persuasive when you're in this little Hollywood Squares box that we're all finding ourselves in so much now. But Ms. Duarte, just before you start thinking too well of yourself, I'm going to say at the end where it was when you were asking the jurors to how they should fill in the jury charge, which is always a good practice. You always want to do that. Get out the charge, show it to them, and tell them how you want them to fill in the blanks. Both of you did well on that. But Ms. Duarte, and these are minor points because I thought overall your presentation was really outstanding. You sort of were telling them what they would do. You know, you will say no, or you have to say yes. Let them come to that conclusion and instead say, we think the evidence clearly calls for an answer of yes to this question or something, so that you're not sort of leaning on them a little bit harder maybe than they want. And then finally, in rebuttal, yes, you got to slam down the brakes. As I said before, I had to put that at the front end as well as closed with it, so you could at least get some shared negligence in the case. I was just talking with somebody yesterday who was involved in a auto accident case in Mississippi or Alabama, and there, you know, they just share the proportionate fault, whether it's 1% or 99%. And in this case, in my view, the plaintiff had to be looking for getting some shared negligence from the driver of the car, because in my view, I think this case kind of favored the defense overall. So anyway, that covers it. Sorry for being so long-winded, but I thought all of you did a really good job, especially when I found that you hadn't really been coached through this exercise in advance. And congratulations to all of you. Very good job.
Casey, thank you so much, Robin and John and Colin. Casey, do you have anything you want to add? No, don't shake your head. I mean, you want, okay, she says ditto to all of that. Okay, then we get to the most important part, why there are people still actually watching this on the live feed. I just checked. I was like, wow, people are still watching. They want to know who won. So that being said, the winner of the very first ever Hicks Thomas and inaugural mid-year death match is the defense, Team Yoo-Hoo and Cocoa Puffs. Congratulations. And thanks to the generosity of Hicks Thomas, and so we got like money to spare, our very first Best Advocate Award of the finals for the finals of the death match goes to Laura Gomez Duarte. So congratulations, Laura. So thank you to all the advocates. We had 28 students, as well as 3 very recent former graduates who came and competed as a ringer team. So I didn't have to deal with buys. Thank you for all of you for your hard work, since I know a majority of this was done over your holiday break, but now for at least 8 of you who are going to be competing on the AAJ team, y'all have 4 to 5 rounds of the problem under your belt before you even get started with your coaches. So that's huge. Hopefully you got some good networking in, because we brought in a bunch of lawyers and judges from like all disciplines of litigation, and particularly Robin, John, Colin, Casey, thank you so much to your firm for your support of the program. I mean, literally, because of your generosity, we've been able to do some really, really cool stuff, as opposed to the last tournament where I just like literally printed out certificates, stuck them in frames from the dollar store and said, here. So thank you so much for making the tournament way, way cooler. So that being said, I'm going to kill the live stream.